Hello. Boom. How's everyone doing? Ah, it's a day. It's been a good day. Um, Everything is going pretty much as thought. So, yeah. Is planting flowers allowed while listening? Of course. Why would it not be allowed? Because, yeah. So, today is an interesting day. We're going to cover a few things. Maybe not as many as some days, but we do have a 46-page document to go over. So that's going to take us a hot minute. And an 11-page document. We also have a couple of lighter stories. And one of the lighter stories is a couple of lawyers getting shot. So, I mean, yeah, it's not lighter as in like it's happy content or anything. It's lighter as in yeah, I guess easier to digest, if that makes sense. So let's somebody's like, that's lighter. Kind of, yes. So where do we start? Well, I guess we start with a goal. And so I got to actually open the thing to let me start goals. Yes, Shot is the lighter story compared to Becky. And the reason why is because Becky's thing is 46 pages. And so when her thing is 46 pages, that is not the lighter story. So we're going to start with a goal for car update, because everybody's been asking me how the car is. And yeah. Low light recovery. A mutual mentioned you. I reached out via X and email. Let me check my spam folders, because that is where those things often end up. And I will try to get back to you later. Aqua, pro bono fund, dog treats, car demudding, whatever. Thanks for all you do, sir. Thank you. Thank you. And I should roll this. Are you bleeding again? I don't know if again is the right word. I feel like the right word is still. So, yeah. I also want to give a shout out to Rosie, who I believe it's her birthday today. So happy birthday, Rosie. Still, yeah, I'm bad at what is it? I've got elven skin. It just slices right open. So yeah, that's probably not the way you wanted me to describe that, but yeah. So I've got a car update goal. I've got a martini. The martini is a bit of a celebration martini. So let's dive in and talk about Carlos Mencia. Now, Carlos Mencia is a comedian asterisk. And I say asterisk because Carlos Mencia is a controversial figure in the comedy community, because lots of people have accused him, and I don't know if there's any merit to it. I just know that people have accused him. But lots of people have accused him of stealing jokes. So, yeah. What are we celebrating? I can't tell you, but we're celebrating. So, in keeping with the whole thing about him being accused of stealing jokes, he's also been accused of stealing, well, sort of, other things. And so, let's have a look here at what else he's been accused of doing. So, felony complaint for arrest warrant. On or about July 15th, 2020, in the county of Los Angeles, the crime of failure to file or supply information for income tax return in violation of Revenue and Taxation Code Section 19706, a felony was committed by Mencia Carlos, who did willfully fail to file a return and to supply information with the intent to evade a tax imposed by Part 10 for the tax year of 2019. So, this was filed June 17th, 2026. And I also just want to note, and I checked Wikipedia before I went with this because I wanted to make sure that this was public information. And it already was public information. But his actual name appears not to be Carlos Mencia. It appears to be Ned Arnell Holes, or Holes? Dude's name is Holes. Ned Holes. I'm just going to say, I feel like he missed the opportunity that really he should have operated under his actual name of Ned Holes. Because if he came out and said, "Hi, I'm Ned Holes," he would get more laughs from that than from anything else in his routine. It'd probably be the first time people lost their shit laughing at a Carlos Mencia, performance. So I'm just saying, like, dude does not know how to do this. All right. So that's count one. Yeah. Count two. Failure to file again for tax year 2020. Count three. Failure to file taxes for the tax year of 2021. Count four. Failure to file for, you guessed it, the tax year of 2022. Did he learn in 2023? No, he didn't. Count five is failure to file in 2023. Count six is failure to file in 2024. Count seven is failure to file or supply information for an income tax return in violation for 2019. Interesting. Why'd they go back to 2019? Then they have 2020. Oh, for part 10 was the other stuff. Oh, it was part 11 before. Now it's on part 10. Now count 9 is 2021. Count 10 is 2022 for part 10. Count 11 is 2023, and count 12 is 2024. And they note, further, as to all of the counts, the offenses alleged are related felonies, a material element of which is fraud and embezzlement, which involved a pattern of related felony conduct, and the pattern of related felony conduct involved the taking of and resulted in the loss by franchise tax board of more than $100,000, thus subjecting to the additional punishment provided for in Penal Code section whatever. And it is to be served in state prison if he is convicted. It is further alleged that the above offenses involved an attempted and actual taking of damage of great monetary value within the meaning of California rules of court. Conviction will require him to provide DNA samples and fingerprint impressions. The people of the state of California intend to present evidence and seek jury findings regarding all applicable circumstances and aggravation. Now, I don't know why this exists. This I might have to talk to a lawyer in California about. Notice a suspected child abuse report may have been generated. Oh, it's may have been, so probably wasn't within the meaning of Penal Code. So when it says may have been for this stuff, usually that means it wasn't, and that that they just don't. So And conviction of this offense prohibits you from owning, purchasing, receiving, possessing, or having under your custody and control any firearms, and effective January 1st will require you to complete a prohibited person's relinquishment form pursuant to the Penal Code. Further attached herein are official reports and documents of a law enforcement agency which they say establish probable cause. The probable cause is going to be pretty short, I'm guessing. So felony complaint, order holding. So charge range 16 to 3, prison, or 0 to 20,000. So, yeah. Carlos Mencia has been charged with some pretty serious tax evasion stuff. Now you might be saying, hey, is that really a big deal? Yes, the government is really a big deal when they decide to proceed with tax evasion, because they can send you to jail for that for like a long freaking time. Did we already hit the goal? We did hit the goal. Okay, I have to start a new goal. All right, we're going to start a new goal of a doggo story. And there we go. So, the car update. I can start off with the car update because the car update is, yeah. So the car update basically goes like this. I was hoping it would be dry because the car is stuck in mud. And instead, we've had enough rain that it almost flooded my house. And I say almost flooded my house because the sump pump got stuck. And I went and was like, okay, why haven't I heard the sump pump running? It is, like it's been raining a ton. Why is the sump pump not running? And the water was just about to the level where if it got any higher was going to destroy the sump pump. So I managed to unjam the thing that, like, the little floaty switch was jammed, and so that's why it wasn't running. And I unjammed it, and the sump pump sprang to life and started pumping water to the house. But unfortunately, we did get some water coming into the basement, so that's fun. And yeah, but so the car is not yet rescuable because instead it has of drying out over the summer to make the car rescuable, it has mudded even further. So I don't know. This car might be super fucked, and I'm gonna have to figure that out. I'm gonna have to like hire a tow truck and so forth once it's dry enough for a tow truck to get in there. But right now it is definitely not that. So yay. Somebody was asking about Ethan Patz, what I think about the decision. I haven't read it yet, so I don't really have a whole lot of thoughts. So that's my take on that, is I haven't read that in. The mud will dry and cement the car in. I know. I got to figure that out. Car may not be salvageable. I got to figure out how to try to rescue it, because I'm going to have to try to wait to, what do you call it? I'm going to have to try to wait to, for it to be like drier, but not super dry, if that makes sense. It's going to be, yeah, a farmer with a good tractor, that is a possibility, but right now it's too wet there for a tractor. So Yeah. Well, it's going to be a project. It's going to be a whole thing. And yeah, get a tractor. I don't have a tractor, but there's going to be people who will try with a tractor. Have I tried kitty litter? They do not make enough kitty litter to rescue this right now. I would need a fuck ton of kitty litter. And yeah. Yeah, right now it's too wet for the tow truck. It's too wet for the tractor. It's too wet to walk in there. Like it's just right now it is mud. I'm lucky the car isn't like sinking into the thing. So yay. Boards under the tire. You guys do not understand how bad this mud is. So yeah, I'm gonna try. We're gonna try, but it's got to dry out a little bit more before we can even try things like tractor or tow truck or any of that. Those will be attempted, but for right now, they are not viable options. All right. I'm going to cover some super chats before we move on to the next story. I know that was a short one, but how far off a road is it? It's a little ways. It's a little ways. Because there was at least one super chat that was hilarious that I need to cover. Vez from Quebec says, I really need to send you that razor. You are not wrong. Jamie Klein, or Jamie Kevin, sorry, happy Monday. Happy Monday. Michigan Farm Boy. I'm glad the lawyer story isn't about one of Runkle's wackos getting to him. No, the wackos are a distance away, I think. Emar or 08 Emir for the celebration and the goal. Thank you so much. It's a me, Tony P. Please tell me the moose took the car for a joyride while you were away. I wish, because that would imply that the car was movable. Pamela Wissenbach, because it's been a rough week and it's only Monday. I need the distraction. Thanks. Thank you. Joy W says, congratulations on whatever you're celebrating, I guess. Thank you so much. Harbinger of imminent death. Please cover the U.S. versus Humani, especially what the new rules are. Does the government now have to show individual cause for anyone they want to ban? Do prohibited categories still exist? Sorry if vague. YouTube blocks words. I know the case you're referring to. I will have to do a breakdown at some point. Glamma Sue, so happy to catch Runkle live on a Monday night. Yippee. Yippee indeed. Is October still within the realm of possibilities? Yes, but we'll have to figure that out. Tax evasion wasn't even his idea. He stole that bit from Wesley Snipes. That was the one I wanted to flag because this is objectively hilarious. Hog Banana, no. The guy who's been accused of stealing his jokes is also now accused of stealing his crimes. Masterful Melon, woot, number 18. I'm so tired, been working since Tuesday. Ooh, I'm sorry. Avrila's Hobby Channel, Anti-Flood Sandbag Fund. Yep. Michigan Farm Boy, all the Carlos counts were part 10 and 11, but the first set were personal, and the second set were as CEO of his corporation. I'm just checking, because, yeah, that might well be the... yes, while being a CEO of a corporation. Yeah. Carlos Mencia, like most people, who do like showbiz in a big way, has a corporation, so that's the issue there. Ms. Behaven, best of luck with the car rescue. Thank you. The Miss Monty, thank you so much. I am looking forward to seeing, because this is going to end up going to court, and so once it goes to court, the question will be, how much does he owe? How much does he owe? Big Apple Hoosier, when is the cookbook happening? I plan my husband's gifts in advance. So the cookbook is planned for, what do you call it? Is planned for November. So it's probably going to be November 7th that I do the Extra Life game day. Probably. I got to figure that out. And so I have to work on getting that done. And once it's done, it's not going to be a physical book because a physical book is a giant pain in the ass. It'll be a digital file. But if you want to take that digital file and get it printed, I will absolutely give permission. I will include a slip in the thing that says, I give permission to print this for, personal use. So, yeah, it'll probably be something like if you donate like $30 or $25 or whatever it is, it'll be, then I will send you an email link to, and you leave your email so that I can actually get in touch with you. Then I will leave you a link to where you can, access the cookbook. And if you want, have one printed. Cause yeah, if I do the like print on demand, what am I munching? I'm having a martini and I was eating one of the olives. So if I do printing myself, then I have to handle money, and I don't want to handle money for the charity. So yeah. It's just kind of a rule is I don't touch any of the charity money. It all goes through Extra Life, because far too many influencers have gotten themselves in trouble going, well, why wouldn't I keep it? And I don't want to be in a situation where anybody can even accuse me of having taken the money, because yeah, I don't want to be in a situation where that is a possible allegation, because there's people who like to throw shade over bullshit, and I just want it to be 100% above board. So let's I think we'll do a lighthearted one, and then we'll go on to Becky Hill, and we'll save the semi-lighthearted one for the end. Are you wanting submitted recipes? I will take submitted recipes, but I can't prove, or I can't promise that I will use the submitted recipes. So yeah, my husband and mother-in-law are fantastic cooks. I will take a submitted recipe, but I will probably want to try it before I do anything. So yeah. There has been a video that is an update to Bricks and Minifigs. And the reason why there's an update is that some guy decided he wanted to intervene. And his intervention is bad. It's not good. So, yeah. Law and Disorder. I need to know if Rob is okay. I miss his streams. Rob is okay. I know where Rob is right now. Rob is having a good time. I just cannot post where Rob is because it's Rob's business. So yeah. But Rob is okay. Rob is doing all right. Doing okay. All right. Let us roll a pup swoop. And thank you so much, Brentwood Chic, for the 20 gifted memberships. That is very generous. And thank you so much. I think I have to roll another swoop for that. So let's talk about how not to crime as our little interjection story, shall we? Because this one feels like it might be a joke. And if it's a joke, if people are playing a joke on me, fine. I will go with it because it's freaking hilarious. 2 arrested after detective finds drugs in a bag labeled definitely not a bag of drugs. I mean, their mistake was assuming the cop could read. Like, didn't they know that the bag says definitely not a bag of drugs? It's even funnier because this bag It doesn't say definitely not a bag of drugs. It says definitely, as in DEFFNTLELY, not a bag full of drugs. It says full twice. And then for some reason, it also says lackey spooge. Now, I tried to look up if lackey spooge was I tried to look it up to see if this was a brand name. And it's not a brand name. I'm wondering if this was homemade. Like, I'm wondering if these people... Now, I see people saying it looks like AI. It does kind of look like AI. So I'm like, what is going on here? Yeah, and yeah, don't look that up with it off. But I'm just trying to... Now I'm doing some additional searching to see if I can, like... Are there other stories? There are other other news organizations reporting the same thing. Is it that everybody got played? Because this feels like it's bullshit. Yeah, I don't know. I want to know more about this. Look up the news affiliate referenced in the screenshot. That's a good thought. Screenshot. I mean, they're citing to the Laurel County Sheriff's Office. Does the Laurel County Sheriff's Office have a thing? Apparently there's a bag on Amazon that is sold like that. All right. Let's see. News. Do they have... Check out what's new on our Facebook feed. Why would I do that? I'm not that old. I'm just trying to see if they've got it. It is a press release on their Facebook feed. So it appears to be legit. Wow. So yeah, just as a general pro tip in life, just because your bag says definitely not a bag full of drugs is not actually going to deter the cops from checking to see if there's drugs in it. In fact, I think they might more think that there's drugs, not less. Because at the end of the day, people who don't have drugs don't typically feel the need to identify their bags as not containing drugs. They just have a bag. So, yeah. It's some life choices. So, all right. Let's talk about Becky Hill. Becky Hill. So, what happened with Becky Hill? If you don't know who Becky Hill is, Becky Hill was the clerk in the case of Richard Alexander Murdaugh Sr., who was charged with murder and was convicted of murder and then was unconvicted of murder, and his matter remanded for a new trial because Becky Boo Becky Hill made some great life choices. Those life choices were that she decided she needed a new lake house. And the way she was going to get a lake house was she was going to publish a book on the Murdaugh case. And she apparently decided that this was the best way to sell her book, basically, was to get a conviction. And so then she put her finger on the scales of justice, and yeah. So Becky denied all of this, and the court did not believe her, and yeah. So Murdaugh's trial gets thrown out. His conviction gets thrown out, and now he's back for a new trial. But Murdaugh also decided to sue Becky Hill. Now, I mean, I don't think he's really looking for the proceeds of her book, because her book is fuck awful. Like, her book is one of the worst things ever. It is a crime against literature, and not just a crime. It's like a war crime against literature. It is the Malort of the written word, which, if you've ever tried Malort, you know just how bad that is. So Murdaugh sued, and now Becky Hill is bringing a motion to dismiss. So this is the defendant's motion to dismiss, and it is 46 pages. And we're going to go over it because that's going to be our Monday Night Fun Day. And yes, her book was withdrawn from sale because she plagiarized key portions of it. And plagiarism is not a crime. It can be a tort of copyright infringement. But yeah. Yeah. So let's proceed from there. So, to plaintiff Richard Alexander Murdaugh Sr., by and through his counsel, you will please take notice the defendant, by and through the undersigned counsel, respectfully moves this court to dismiss plaintiff's complaint for failure to state a claim upon which relief can be granted or for this court's lack of subject matter jurisdiction pursuant to 12b6 or p12b1. So the thing about failure to state a claim is that you have to take the pled facts, the well-pled facts, as true for the purposes of the motion to dismiss. And the reason why they have to be taken as true is because the plaintiff hasn't had a chance to prove anything yet. And so they have to get the chance to prove it, right? So if the well-pled facts support a claim, then it proceeds on. If not, then it doesn't. So, defendant moves pursuant to 12b6 of the Federal Rules of Civil Procedure for dismissal of plaintiff's suit based upon plaintiff's failure to state a claim for relief. Plaintiff alleges, in short, that defendant's actions deprived him of an impartial jury and that he is therefore entitled to recover the full sum of the money he spent. Okay, that's great. We've made it into the second paragraph before we've hit the first typo. 2 paragraphs in. On his criminal trial defense. Such damages fall outside the scope of 42 U.S.C. 1983 and 1988. The Fourth Circuit has never established that damages stemming from the legal costs associated with defending an underlying criminal case are redressable under the statute. Yeah, but I feel like these are unique facts. Like, they're like, they've never said that this can be repayable. It's like, how many times has this ever happened, though? Like, this is the kind of case that makes new case law on that. Further, to the extent that other circuits have considered the question, they, along with the Fourth Circuit, have been clear that in the event such damages are recoverable, a plaintiff must show that his damages were caused by the defendant's actions. Such cannot be the case here, where the entirety of the economic damages claimed by the plaintiff would have been spent on his criminal defense, regardless of any actions taken by this defendant. Yes, but you're the reason why they were wasted. Like, they would have been spent either way, but you're the reason why they were pointless. You're the reason why they didn't matter. Similarly, and for much the same reasons, defendant is entitled to dismissal of plaintiff's claims pursuant to Rule 12b1 of the Federal Rules of Civil Procedure, where the compensatory damages sought by the plaintiff are not traceable to the defendant's actions. Finally, to the extent, if any, that plaintiff argues otherwise, that inconsistent with his complaint, he seeks damages related to the second future trial. So this is basically a mistake. They're like, you didn't plead damages for the future trial. So, yeah. Defendant likewise moves to dismiss plaintiff's complaint under Rule 12b1 of the Federal Rules of Civil Procedure. Under such a theory, plaintiffs damages have not, and indeed might not ever accrue, and plaintiff's suit would not therefore be ripe for adjudication, divesting this court of jurisdiction to entertain the same. I actually don't think this argument is completely terrible. I don't think it's going to work, but I don't think it's completely terrible, because they're like, look, he would have spent the first trial money, so we can't claim that. And he can't claim the second trial money yet because he hasn't had the second trial. Now, I suspect that the way the court is going to deal with this is they're going to say, no, he can claim whichever one he wants. That's up to him. So, yeah, this is kind of the thing. I don't think it wins, but I don't think it's frivolous, right? I don't think it's at the point of like, this is complete bullshit. I just don't think it's likely to win on this point. So, memorandum in support. Defendant submits this memorandum in support. We're going to skip over that. So they note, plaintiff alleges, in short, the defendant's actions deprived him of an impartial jury, and that he is therefore entitled to recover the full sum of the money that he spent on his criminal defense. Such damages fall outside the scope of 42 U.S.C. and 1983 and 1988. The Fourth Circuit has never established that damages stemming from the legal costs associated with defending an underlying criminal case are redressable under the statute. Further, to the extent that other circuits have considered the question, they, along with the Fourth Circuit, have been clear that in the event such damages are redressable, a plaintiff must show that his damages were caused by the defendant's actions. I find myself coming up with sort of a parallel line of thinking here. And the parallel line of thinking goes like this. Let's imagine that I am building I'm having a statue commissioned of Bob. I am so impressed by Bob that I'm having a statue made. And I hire a sculptor to make the Bob statue. Now, some villain, we'll call this villain Becky for no reason, no relation, just a different Becky. But some villain sneaks in and takes the concrete that is going to be used to make the statue and mixes in some sort of contaminant that prevents the concrete from ever properly setting, right? And so because of that, the statue is ruined. And so then I sue this other no relations Becky. And so when I sue Becky, Becky is like, no. You were going to spend the money on the statue anyway, and you haven't built the replacement statue yet, so I shouldn't have to pay. And I'm like, that does not make sense to me. It makes no sense to me. So I don't know. I feel like this is defeatable. So, all right. So a lot of this is the same as what we've just seen. And finally, and most critically, even had plaintiff stated a compensable claim, defendant is nonetheless entitled to 11th Amendment immunity, quasi-judicial immunity, and qualified immunity, all of which bar plaintiff's suit. Now, this is interesting. 11th Amendment. I don't deal with the 11th Amendment doesn't come up a whole lot. But the 11th Amendment states, the judicial power of the United States shall not be construed to extend any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens of subjects of any foreign state. Okay, interesting. Like, this is kind of a procedural wrinkle. Now, this, I'm like, I got to do some research on this one. I want to see the arguments. And yeah, you need the first trial's money back so you can pay for the new one. The other problem here is that Becky doesn't have murder trial money, I don't think. I don't think Becky has speeding ticket trial money right now. Like, Becky can't be rolling in cash. I think that this is really just kind of a fuck you, Becky lawsuit where they're going to try to bury Becky in fees and, and damages and just be like, fuck you. So, standard of review. We're going to skip over the standard of review because I've stated this in a whole lot of videos, and also I restated it sort of in this video. So, the fundamentals of standing are well known and firmly rooted in American constitutional law. To establish Article 3 standing, a plaintiff must identify 1, an injury that he or she suffered, 2, that can be fairly traced to the defendant's conduct, and 3, that will likely be rectified by the relief the plaintiff seeks. So, argument. Plaintiff alleges that during the course of his criminal trial for the murders of his wife and son, which began on January 23rd, 2023, and ended March 2nd, 2023, defendant Becky Hill had made multiple improper contacts with and made multiple improper prejudicial comments to the jury. So on May 13th, the South Carolina Supreme Court set aside plaintiff's murder convictions and ordered a new trial upon finding defendant's actions were improper and presumptively prejudiced the jury's verdict. They also found that Becky lied in court. Plaintiff brings the instant civil suit under law, seeking to recover compensatory damages for defendant's alleged constitutional violation of Murdaugh's Sixth Amendment right to a fair trial by an impartial jury, secured by the 14th Amendment. Plaintiff seeks compensatory damages in the amount of $600,000, which represents the flat fee paid to plaintiff's legal defense team, a combination of attorneys from Griffin Humphreys and Richard A. Harpootlian, a.k.a. Poot, a.k.a. Dick Poot. Like, the guy's literally named Dick Poot. I can't make this trial up, folks. This trial is redonkulous when you've got Dick Poot involved for their work in his underlying state criminal trial. By the way, $600,000 for a murder trial of this complexity is actually kind of a bargain. Plaintiff does not contend defendant's alleged constitutional violation of Murdaugh's Sixth Amendment right to a fair trial by an impartial jury, secured against the states by the 14th Amendment, caused plaintiff to incur the additional legal costs of defending any post-trial and appellate litigation or future retrial. Rather, plaintiff seeks to fund such a possible retrial pursuant to a novel theory of recovery under... Now, I just want to note, novel theory. Novel is one of those words that has a different meaning in law than it does in most other places. So, if I say that a physicist has a novel theory in the field of physics, I'm probably praising that theory. I'm like, this guy's real clever. He's got a great idea. It's a new idea. No one's ever thought of this. If I say an engineer has a novel invention, that's definitely praiseworthy, right? They've invented something that no one thought, so like the internal combustion engine was novel when when it was first invented, right? It was a novel idea. But in law, you're not supposed to be forging your own track most of the time. In law, typically where you want to be is, Your Honor, my idea is not clever. It's not new. It's not a surprise to anybody. I am going in the old ruts that are, carved by by every wagon that has been here. You want to say this is so fucking obvious at this point that a toddler should get it. That's where you want to be in law. Novel is pretty close to, Your Honor, he's full of shit. That's what novel means in law. Now, novel is the kind of art, is the kind of thing you only want to say very, very carefully. And what I mean by that is that if you snark too close to the sun in your filings, then the court will punish you. Novel is the kind of thing that the courts will say when they've kind of lost patience with you. So, like, if the courts think you're full of shit, the courts might say, defendant brings a novel argument. And it's a way for the court to be like, yeah, this is kind of full of shit. But if you call the other person novel, then the court might be like, that is my word. You do not get to use that word. You don't get to accuse them of being novel. I do that. So you got to be careful. So rather, plaintiff seeks to fund such a possible retrial pursuant to a novel theory of recovery, contending that defendant's alleged constitutional violation caused the entirety of his underlying state murder trial and his economic loss of the funds spent in defense thereon. So what the defense is arguing here, what Becky Boo is arguing, look, you would have spent that money anyway, right? You were going to spend a whole bunch of money on this stupid bullshit, and therefore you don't get to claim shit, right? You were already going to spend this money, so you can't claim it because it's not money that's a loss. It is just money that you were going to spend either way. And so, tough shit, right? But the response to that is going to be something like, yeah, we would have spent the money either way. Like, either way you slice it, we were going to spend this money. But you're the reason why this money is wasted. You're the reason why this money doesn't go anywhere. And if we want to pick a bit of an extreme example, right? Extreme example. Let's say Bob is doing real bad. Bob's got cancer. And Bob is getting chemo. And, some villain, we'll call this villain Hill, goes in and takes the chemo drugs and pours something into them that renders them inert. They don't steal them. They just render those chemo drugs inert. And so Bob is getting his cancer treatment, but this Hill villain has rendered the chemo inert. It doesn't do anything. Bob does not live. Bob dies. His cancer takes over. Bob is dead. Rest in peace, Bob. And so I find out that this was tampered with, and I sue as the estate, it turns out I was also listed as the sole beneficiary in Bob's will and the executor. And so I sue this Hill villain and I say, look, you fucked with this. Would we accept this notion of, well, you were going to spend the money on chemo anyway, so you have no damages because I didn't cause you to spend the money on the chemo. You were going to do that either way. And you didn't spend money on new chemo because Bob died. I feel like this would be super unsuccessful. And the only way they can get to this maybe being arguable is that it's in the context of a criminal trial, right? Now, imagine that Bob doesn't die. Bob is just, Bob is sick. And Bob is like, I need chemo. But we already spent all the money on the chemo and we got fake chemo. We got bullshit. Would we accept the notion that we can't get the damages for the original chemo drugs, but we can only get the damages for the future chemo drugs, and we can't afford the future chemo drugs because we can't get the damages for the past one, so therefore the damages are zero because there's just no money? And I'm like, I feel like this argument would also not fly. So these arguments, the instant you take them out of the sphere of, the instant you take them out of the criminal trial framework, they fall apart in a big way. And so if Murdaugh's lawyers are smart, they are making a lot of arguments from analogy. Now, I like arguments from analogy. You may have recognized that in my discussions. I am the guy who went to the Supreme Court of Canada and described a police officer's actions as a 10-beer situation. And that was an analogy between the police officer asking my client some questions he wasn't supposed to and drinking and driving. I like arguments from analogy. I pull them out in all sorts of weird places. And like the 10-beer situation. But I feel like here they need to argue the chemo situation. They need to argue all of these things because those are, I feel like there is a win here. All right. So the foundational principles of 1983's remedial provision bar plaintiff's recovery of legal defense fees incurred in connection with his underlying state criminal trial. Plaintiff's suit is based upon a novel theory. They're going to say novel a lot. Of liability and recovery. To the undersigned counsel's knowledge, this is a case of first impression. No federal circuit or district court has addressed the question of whether a criminal defendant who alleges their Sixth Amendment right to an impartial jury has been violated can recover damages for the legal defense fees incurred in connection with the underlying state criminal proceeding in a subsequent civil suit brought pursuant to the law. They're like, no court has ever found this. And I'm like, when the fuck has there ever been a Becky Hill? Because they're just like, the shit Becky pulled is not like regular shit. It's not like, the shit you might find in your backyard or even the shit you might find on like a horse trail or whatever. This is like you walk outside in downtown Edmonton and you go to get your mail and you look over and there is like velociraptor shit. And you're like, I didn't know there were any velociraptors, and I certainly did not know that they were like in Edmonton. That is a weird place for them to be. Shouldn't they be in in some sort of park or island or something like that. And so the fact that Becky Hill has infringed in a way that is unusual and that really nobody has ever infringed like before does not, to me, say that Becky is doing a great job. Right? It doesn't, to me, say that Becky is, it doesn't, to me, say that Becky's fine. It says instead that we're talking about somebody who is exceedingly shit in unique and unexpected ways. So I don't know that this argument is the one that is going to carry the day for them. Because quite frankly, if I'm the judge, I'm reading this going, but your client is like so extra shit. Like your client is so extra bad that nobody's ever thought of this. But that doesn't mean that you are, that. Yeah, I don't like this. So, even expanding this inquiry beyond the narrow scope of the Sixth Amendment, the Fourth Circuit has never directly addressed whether a 1983 plaintiff can recover attorney's fees incurred in connection with an underlying state criminal proceeding. Yeah, they probably haven't had to address this. And the thing is that if this lands in front of the wrong judge, this is bait for a certain kind of judge, because there's a certain kind of judge who's going to look at this. And their reaction isn't going to be, oh, this is bullshit. Their reaction is going to be to salivate. Because there's a certain kind of judge that's going to look at this and they're going to say, look, this is the absolute most fucked up thing that has ever happened, and it's an opportunity to create the law. This judge is going to be like, if I do this, I'm going to be taught in law school classes. I am going to be taught, like, people are going to have to cite my case at the bar exam. Like, the wrong judge is going to love all of this, right? It's like, oh, now I get a chance to write an entirely new chapter and stamp my fucking name on it. Like, this is the kind of stuff judges do when they, like, if that judge has ever thought, man, it might be nice to be on the Supreme Court, they're looking at this case going, oh, yeah, me and you need some alone time, case. So, yeah, you don't want to make the judge think they need some alone time with your case. Or if you do, you want them to want to do it on your side. So, as such, the common law of torts provides the appropriate starting point for the damages inquiry under 1983. So, the general purpose of damage under 1983 is to compensate persons for injuries that are caused by the deprivation of constitutional rights. Yeah, I mean, I feel like the injury here is that he spent a whole bunch of money and that you made that money worthless because you fucked around. Like, you wasted that money on his behalf. So, deterrence is also an important purpose of the system, but it operates through the mechanism of damages that are compensatory, damages grounded in determination of plaintiff's actual losses. Like the common law tort claims upon which 1983 were modeled, claims brought pursuant to 1983 require both but-for and proximate cause analyses. So, the Supreme Court has instructed, in order to further the purpose of 1983, the rules governing compensation for injuries caused by the deprivation of constitutional rights should be tailored to the interests protected by the particular right in question, just as the common law rules of damages themselves were defined by the interests protected in the various branches of tort law. Ordinarily, then, the compensation awarded under a proven constitutional violation is governed by the interests intended to be protected by the right and by the damages foreseeably stemming from that right's violation. In the instant case, however, plaintiff prays for damages consisting of the entire cost of the underlying criminal trial, during the course of which plaintiff alleges the defendant violated his Sixth Amendment right. The Fourth Circuit has never recognized 1983 as countenancing such a broad grant of damages, and those circuits that have addressed the issue have predominantly rejected such approach. I mean, but Becky Hill is a very special level of shit. And, like, I don't think that the damages request is unreasonable. I think he's got some other problems for that, but that I don't see how you immediately get to, how you immediately get to that, right? So, all right. Work as a clerk, she should be in jail. Becky's cost the state and counties of South Carolina millions. In a county where there's so much need, Becky's messing around with the judicial system. I think it's actually pretty horrific that she skated on probation. Like that, she should have gotten jail. She should have gotten a lengthy jail sentence. Like, it should have been an honest question as to who would be getting out first, Becky or Murdoch. And it honestly would probably be a race to which one gets to the pine box first. Because, yeah. Like, that's my feeling on that one. Federal circuits are split as to whether 1983 permits recovery of legal fees incurred during an underlying state criminal procedure. I mean, split is not really a good thing on your side, but okay, go off, King. There's a split of authorities on the issue of whether a criminal defendant whose constitutional rights have been violated in the underlying state criminal proceeding can recover damages for incarceration, legal costs, and/or fees or emotional distress in a subsequent 1983 suit. So, compare Towns versus City of New York. Defendant first addresses the Second Circuit's approach. In Towns, the Second Circuit panel rejected the 1983 compensatory damages claim relating to his conviction and incarceration stemming from a Fourth Amendment violation. Okay. Fourth Amendment violation is a search. That's a very different thing. Because the difference between an unlawful search and jury tampering is huge. Let me explain. So, in this case that they're talking about, the search was they searched a taxi cab and they found a gun. And the person was, convicted for having the gun. And the thing is that fundamentally, the dude had the gun. Right? That is the fundamental thing. And sure, maybe they shouldn't have found the gun. But that doesn't change the fact that the dude had the gun. Right? Whereas that's very different from I got the jury to, I got the jury to convict by, telling them to disregard the evidence of the, accused. That's an incredibly different scenario. I do not find that those two amendments are equal in their consideration. I am like, are you kidding me here? So after over 2 years of incarceration, the state appellate division reversed the conviction upon finding the police lacked probable cause to seize and search the taxi cab, which subsequently resulted in dismissal of the indictment. Of course it did. They found that the gun was inadmissible, so they're not going to convict him on possession of the gun when they can't talk about the gun, right? So, Second Circuit panel first held the fruit of the poisonous tree doctrine cannot link the unreasonable seizure and search to Towns' conviction and incarceration because this evidentiary doctrine is inapplicable to civil 1983 actions. Okay, so they even pinned it to search and seizure specifically. Their argument is taking me even further from their point. This is a bad thing when your argument leads me to think more and more that your argument is bad. It's like you are convincing me away from your position. I already wasn't super sympathetic, but you are arguing me out of your position. So, yeah. The panel explained that the fruit of the poisonous tree doctrine is calculated to safeguard the constitutional rights of suspects by deterring future unlawful conduct by state actors through incentive, avoidance of the suppression of illegally seized evidence, rather than creating a personal constitutional right for the party aggrieved. I feel like that is wholly different than that's wholly different from the right to a jury trial, which I think is absolutely a personal constitutional right for any aggrieved party. Are you fucking kidding me, guys? This lawyer is not thrilling me here. I am unfucking thrilled right now. The panel found that the doctrine's deterrence objective had already been achieved, though late, by the rulings of the Appellate Division and the Court of Appeals, and reasoned that extending the doctrine to 1983 actions would impermissibly recast the relevant proximate cause inquiry to one of taint and attenuation. Second Circuit likewise found that the plaintiff's incarceration was not proximately caused by the alleged Fourth Amendment violation. So basically they're saying that his incarceration was caused by his decision to have a gun, not by his decision to, or not by the unlawful search. But this is, again, a major difference between all of these. Thereafter, the panel discussed a second independent reason for which plaintiff was foreclosed from recovery. Recovery of compensable damages was improper where the injury plaintiff pleads does not fit the damages he seeks. The Second Circuit panel pointed out that the gross disconnect between the constitutional violations, the Fourth Amendment right to be free from unreasonable searches and seizures, and the injury or harm for which Towns seeks a recovery, his subsequent conviction and incarceration, explaining the evil of an unreasonable search or seizure is that it invades privacy, not that it uncovers crime, which is no evil at all. Holy shit! The response to this writes itself. Because the evil of a jury tampering issue is not that it invades privacy, it is that it denies you the right to a fair trial, which is in fact an evil. I could write the response to this in my fucking sleep. And I don't even need to be having a good dream for it to be going down. Like, it doesn't have to be like a flying dream or anything like that. We could be like, you know, if Freddy Krueger shows up in the dream, I'm like, dude, hand me a pen. We're going to get this shit done. And then you can do the murdering. But like, you know, like the way this is written invites dunking on. Like, this is one of those things where it's not hard to write the response. It's hard to write the response without being so sarcastic and shitty at the other side that it pisses the judge off. Because I'd be like, Judge, look at how fucking dumb this shit is. I don't think this was written by ChatGPT, but I feel like maybe they should blame it on ChatGPT. So the panel concluded this gross disconnect ran afoul of the Supreme Court's directive to tailor 1983 liability to fit the interest protected by the particular constitutional right in question. You mean like the fair trial right? Moreover, the panel reasoned that no Fourth Amendment value would be served if plaintiff reaped the financial benefits sought, in addition to already reaping an enormous benefit by reason of the illegal seizure and search to which he was subjected, his freedom. Holy fuck! This again writes the response. Like, when I'm looking at this, I'm like, oh man. No Fourth Amendment value would be served if plaintiff reaped the financial benefits sought. I'm like, but a Sixth Amendment value is absolutely served if Mr. Murdaugh is compensated to allow him to marshal a defense on his second trial, which otherwise, because the Sixth Amendment is not protected at all, if the result of this is that he burns all of his financial resources on the first trial and does not have them available to run the second trial, then the injury from the Sixth Amendment is magnified. In fact, compensation is necessary in this case in order to protect the fundamental Sixth Amendment protections. Because if compensation does not flow, the Sixth Amendment here is gutted and bleeds out on the road. Maybe I wouldn't use that exact language, but you get where I'm coming from here, right? Hopefully you can see just how much this opens them up to the response. Man, this is the kind of thing where if I was barred in the US, I'd be reaching out to Dick Poot going, Dick, or would you prefer I call you Poot? Can I write like a first draft of your response? You don't have to, make it your final draft, but let me write the first draft because this would be fun. And you know what? I won't even charge you any money for it. The only thing you need to do, Dick Poot, is promise not to point any guns at me, because I know how much you like pointing guns at humans. And, you did that in court. So long as you promise not to point any fucking guns at me, we'll be I'm happy to help out. So, yeah. It's like, Dick Poot, I'm going to work remotely so that there's no possibility of you getting shot or you accidentally shooting me. So, all right. The panel reiterated the purpose of suppression is to deter state actors from unconstitutionally invading into law-abiding citizens' privacy, and to compensate the plaintiff for his conviction and time served would vastly over-deter police officers and would result in a wealth transfer that is peculiar, if not perverse. Yeah, I don't feel like that's the case here. I feel like Becky Boo is skating, not being over-deterred. Because, quite frankly, I don't think Becky Boo would be being over-deterred if the court, sentenced her to kidney stones the size of a grapefruit. I'd be like, yeah, we're at about right. I don't know how the court's going to make this happen, but I feel like that is the right amount of deterred. And yeah. Okay. So the panel affirmed the dismissal of plaintiff's complaint for failing to seek the only relief to which he may have been entitled. Alternatively, in Burundi, the Ninth Circuit rejected the appellant's contention that admission of the amount of attorney's fees expended by respondents during the prior state criminal proceeding as an element of 1983 damages was a prejudicial error. The Burundi respondents were previously charged with resisting arrest, assault on a peace officer, and public intoxication by the appellant officers. After a jury trial, the respondents were acquitted on all criminal charges and subsequently brought a 1983 action against the appellants. After a 4-day trial in the 1983 action, the jury returned a special verdict in favor of the respondents, awarding them both approximately $11,000 each, which is basically nothing. So, yeah. First, the panel quickly disposed of the two cases cited by the appellant in support of this proposition as inapposite, because the cases involved attorney's fees awarded pursuant to 1988, not 1983. Next, the panel found the respondent's expenditures for legal representation during the prior criminal proceeding most assuredly constituted economic harm, which is a compensable injury. The Ninth Circuit panel held that the reasonable amount of these expenditures for legal representation, if proved to the jury's satisfaction to be the consequence of appellant's illegal conduct, is recoverable as compensatory damages. Okay. They rejected the appellant's argument that their illegal conduct did not proximately cause the expenditures of attorney's fees in defending against the criminal charge, because the prosecutor's decision to prosecute the case was an intervening and superseding exercise of independent judgment. While recognizing that the prosecutor filing the criminal complaint is presumed to have exercised independent judgment in determining that probable cause for an arrest exists, the panel found that petitioners had submitted sufficient evidence to challenge the presumption. I mean, this also feels like it helps Murdaugh. And I mean, I'm going to be clear here. Murdaugh is a sack of shit, because at the best, Murdaugh stole a whole bunch of money from vulnerable people, and, you know, Murdaugh is like an absolute garbage human, and that's like at the best. He may also have killed his family. We don't know. But that doesn't mean that Becky Boo is not a garbage human, or that she doesn't owe the fucking money. I feel like she should owe the money here. So, the panel determined that based on the evidence presented, the jury was entitled to find that appellants procured the filing of the criminal complaint by making misrepresentations to the prosecuting attorney. Thus, the amount of attorney's fees incurred during the criminal prosecutions was a direct and foreseeable consequence of the appellant's unlawful conduct. Okay. So Barunda is very much helpful to Murdaugh, and I guess they're citing it just to say, look, there are some cases in their favor. This is the ethical and proper thing, by the way. If you have cases that go against you, you should reference them. But I feel like Barunda is much more apposite on these facts. The Third and Seventh Circuits have adopted the town's rationale and rejected Barunda. So, but they're citing to a case that is an unlawful search. And set in motion by an arrest. What was the violation? What was the rights violation in Martin versus Martinez? Because I feel like the distinguishing factor on all of this is, in fact, not the issue of... I feel like the distinguishing factor is what right was violated. Because you can say, if it's a search issue, okay, the issue is just the privacy. But a jury tampering issue is a very different scenario. And I don't feel like the two of them actually really connect very well at all. So, this court should adopt the Second Circuit's rationale barring recovery of legal fees incurred in an underlying state criminal proceeding in a subsequent 1983. I don't feel like I feel like these cases can all be reconciled, and that the reconciliation of all of these cases together benefits, benefits Murdaugh. Domestic cattle kill more people in the UK than sharks kill worldwide. Shark injuries are thankfully rare. Yeah, but people spend a lot more time hanging around cows than they do around sharks. I feel like if we had domestic sharks that like farmers spend time with, we would have more shark attacks. But like, my risk of shark attack is very low at any given moment because of there is no ocean here. A shark would have to take the bus to get to me, and they're just like they're not good at that. So, um, Towns is the proper persuasive authority for this court's determination of the issues presented by plaintiff's complaint. I would dunk on this all day long. Defendant submits that the Third and Seventh Circuit adopted Towns as opposed to Barunda because the Ninth Circuit's decision improperly omits any discussion of the Supreme Court's tailoring instruction. So they're saying Barunda is just a bad case. So the goal of the court's 1983 jurisprudence has been to tailor liability to fit the interest protected by the particular constitutional right in question. Holy shit, that is exactly the line I would be looking to quote if I'm Murdaugh's counsel. Because if I'm Murdaugh's counsel, I'm absolutely saying the goal is to tailor liability to fit the interest protected. In this case, the interest protected is a fair trial. And the only way we get to protecting the interest of a fair trial is for Murdaugh to be able to recover damages in order to fund his defense. Because if Murdaugh is not able to fund his damages or fund his defense through those damages, then he cannot be made whole. Lady Tanya, I don't think the response is out yet. But when it comes out, you better believe I'm going to be covering it. I don't think it's out yet, but I will cover it because holy shit. Yeah, when was this filed? We're at page 12, so I'm just... Yeah, this was filed 4 days ago. We're not going to have the response yet. I'm like, could I have missed it? No, it wouldn't have been done yet. Failing to consider the tailoring of liability. The tailoring of liability doesn't help you here. I don't see how it helps at all. To fit the interest protected by a given constitutional right, the Ninth Circuit focused solely on the theory of proximate causation when assessing the plaintiff's entitlement to compensatory damages under 1983. The Ninth Circuit grounded their decision with support from Kerr versus City of Chicago, finding Kerr permitted a plaintiff in a civil rights action to recover the attorney's fees in a state criminal action where the expenditure is a foreseeable result of the acts of the defendant. The Seventh Circuit, however, has since made clear that Kerr is not controlling precedent in 1983 actions brought by criminal defendants seeking damages for incarceration, legal costs and/or fees, or emotional distress stemming from a Fourth or Fifth Amendment violation. Is it a Fourth or Fifth Amendment violation? Or is it a different amendment? Because I feel like those are different things. So, in rejecting the Martin plaintiff's contention that Kerr established that he was entitled to pursue damages for his post-arrest incarceration, the Seventh Circuit explained the precise issue in Kerr was whether the plaintiff should have been allowed to present evidence in his civil case of attorney's fees expended in his underlying criminal case, which hinged entirely on his involuntary confession. The Seventh Circuit panel further explained that Kerr addressed the precise interest which the Fifth Amendment protects, the right not to be compelled in a criminal case to be a witness against oneself, as the damages sought, the expenses of defending the criminal trial prosecuted on the strength of the involuntary confession, arose directly from the constitutional violation. So, moreover, Moreover, Barunda and Kerr dealt with evidentiary issues inapplicable here. So, Barunda was whether the district court had erred in admitting evidence of their prior acquittal and evidence of attorney's fees spent during the criminal proceedings. The factual circumstances here are likewise distinguishable from Barunda, in which the jury there found the officers lacked probable cause for the arrest. Here, plaintiff is not alleged, and indeed cannot allege, that any action of defendant affected the probable cause upon which the plaintiff's prosecution and trial were based. Okay, fair enough. He can't allege that. But he can allege that the money he would have spent would have been usefully, would have been actually productively spent if that was allowed. Don't like this at all. I do not like their arguments. No, I do not. So, carrying on. Ninth Circuit failure to address the Supreme Court's tailoring instruction and the distinguishable factual and legal issues on appeal in Barunda demonstrate that Towns is a more appropriate persuasive guide to this court's analysis on the instant matter. If I am the court, I am not agreeing with them in the slightest on this analysis, but I would instead be different and saying, look, these are reconcilable cases. The Fourth Circuit has favorably cited to Towns. This certainly suggests that the court is not disapproving of the analysis. And I'd say, look, if I'm the judge, I'm saying, look, Towns is good law. Towns is excellent law. But Towns doesn't help you here because Towns applies to Fourth Amendment violations, and this is a Sixth Amendment violation. And the distinction is the type of injury. And that here the type of injury requires compensation because otherwise we just do further violence to the right to a fair trial. So, all right, we're going to skip over a little bit more of this. They say more towns, more towns, more towns. And we're going to take a little bit of a brief moment because we hit the goal. And I'm going to tell you a doggo story because we hit the goal. So, Mrs. Runkle has been working out of the house, and I have been working in the house for the past little bit. And so what does that mean? It means that Zora wants to find Mrs. Runkle when she's not in the house. So Zora's like, I need to go and check if she's in the backyard because, maybe she's hiding in the backyard. Zora will go, she will sniff her way to the back gate, determine that Mrs. Runkle went through the gate, and then she's like, all right, that's as far as we're getting. Like, she went through the gate. It's all wolves and, fire and whatever else, right? So, that's Zora's investigation. But the rain that has been coming here has been overflowing the gutters. And so in front of the back door, there's been drips coming down. Now, Zora was willing to brave the drips in order to go out into the backyard to look for Mrs. Runkle. However, that's as far as she was willing to go. Because then she wanted to come back into the house to, hang out with me as, compensation for the, it's like, well, okay, I guess you're second best choice. But she didn't like me well enough to venture through the drips. So she's like, I want to come in, but I don't want to go through the drips. And I'm like, seriously? So I had to go and get my coat and hold my coat out as an awning for this dog so that I was shielding from the drips. And then Zora was willing to come back inside and be like, all right, fine. okay, cool, whatever. And I'm just like, this little fucker of a dog. She loves me. She loves us both. She loves Mrs. Runkle way more. But she's like, I cannot sully my hide. So I'm like, all right. And meanwhile, if I was as tough as I like to think I am sometimes, I would totally have just been like, okay, Zora, you can stay outside, do what you want. But instead, I am a sucker. I am a sap. And so what I do instead is I let the dog in and shield her from, shield her from the rains. And yeah. She's a sweetheart. All right. So there's no causal connection between defendant's alleged constitutional violation and the attorney's fees incurred by plaintiff in his underlying criminal trial. This is where they're going to say you would have spent that money anyway because of the murder allegations. So plaintiff is not entitled to recovery of his expenditures for legal representation in his underlying criminal proceeding. Plaintiff asserts he funded his murder trial defense with a $600,000 withdrawal from his 401k retirement funds, which was his sole remaining asset. Initially, the loss of such attorney's fees may constitute monetary harm, potentially compensable under 1983. Plaintiff, however, has failed to feasibly allege that defendant's action caused these funds to be lost. I mean, it caused the trial to be lost. So, plaintiff cannot recover compensable damages here because the injury he pleads does not fit the damages he seeks. Defendant's alleged constitutional violation was neither but for or proximate cause of plaintiff's underlying criminal trial. The damage isn't that the trial happened. What I'd be arguing here is I'd be saying, look, the damage isn't that the trial happened. The damage is that the trial was rendered pointless. The damage is that the trial was rendered unfair. And that this money shouldn't have been spent because your actions fucked it up. So, yeah. Unlike the criminally accused in Martin Towns, etc., the initiation of the underlying criminal charges here had no connection to defendant's alleged constitutional violation. The plaintiff's criminal trial did not hinge entirely on defendant's alleged constitutional violation, nor did the expenses of defending the criminal trial arise directly from the alleged constitutional violation. No, but the fact it was wasted. Yeah. So plaintiff's underlying murder trial, yeah. Rather, plaintiff's murder trial was initiated by the Attorney General of the state of South Carolina's exercise of independent judgment in deciding to prosecute, and the Colleton County Grand Jury's exercise of independent judgment in indicting plaintiff. While the prosecution's election to proceed with the indictment of the plaintiffs in Collins and Vaughn were superseding proximate causes, severing the chain of causation between the constitutional violation of the plaintiff's trials, here, the state's decision to prosecute and the grand jury's indictment of plaintiff were the sole but-for causes of his underlying murder trial, and in turn, the sole but-for causes of the economic injuries allegedly suffered. All right, let's consider another ridiculous hypothetical. Let's consider another potential ridiculous hypothetical example here. And that is Becky decides not to do jury tampering. She's like, jury tampering, it's too slow, it's too imprecise. I don't know if it's going to work. So instead, she just smuggles a battle axe into court. Or she smuggles in a sword. And, she keeps it at her clerk's table and, just And then before Dick Poot can begin his direct examination of his client, she jumps up over the table and she stabs Dick Poot to death. And now Murdoch goes, I want to sue for the damages because all of this money I spent on Dick Poot to prepare for trial, I'm going to have to pay another lawyer to do all this prep work again. I feel like that would be justified and couldn't be defrayed with, well, you were going to have a criminal trial anyway, regardless of whether, anybody murdered Dick Poot. So, like in our hypothetical murder example, you can see how this argument doesn't really make a whole lot of sense to me. So I like this one. What's the legal phrase doctrine for novel fuckery requires novel solutions? I don't know, but I want to find out. Like, I feel like that is exactly the kind of argument they should make there. Things we do for our doggos. We said goodbye to our 16-year-old doggo last week. I miss her peccadillos. Here's to all the good doggos. I know that one day I would give anything to be sitting there holding a jacket out for Zora to walk in under. But yeah. So I get it. I feel it. I worry about it at times. Like, how will I deal with that? All right. Allowing plaintiff to recover the attorney's fees incurred during the underlying criminal proceeding, which was set in motion by a grand jury indictment supported by probable cause, would amount to precisely the sort of mismatch between the violation and damages that Towns and Hector sought to avoid. Except in this case, it's not a mismatch at all. It's a perfect match. He's got a right to a fair trial. You prevented him from having a fair trial, and he needs the damages to have the fair trial. So I feel like that is exactly the thing. So plaintiff's underlying criminal proceeding then was not the natural consequence of defendant's actions, and awarding plaintiff's legal fees incurred therefrom would not compensate him for any injury caused by the alleged deprivation of his Sixth Amendment right to an impartial jury. They also said Sixth Amendment and not Sixth Amendment. But yeah. I don't know. I feel like it is, in fact, the natural consequence that somebody loses their legal fees if they don't get a fair trial. So, yeah. It's not the abstract value of a constitutional right, even one central to our system of ordered liberty, that forms the basis for 1983 remedies. Rather, it is proof of actual compensable injury. I mean, the actual compensable injury is that he was denied a fair trial, and he spent a whole bunch of money to try to get a fair trial, and he was denied that. So, yeah. Yeah. Rights, constitutional and otherwise, do not exist in a vacuum. Their purpose is to protect persons from injuries to particular interests. Plaintiff has alleged no damages related to his protected interests under the Sixth Amendment, but rather has exclusively alleged injuries that resulted from his criminal prosecution. There is no evidence, nor can it be reasonably inferred, that any damages resulted from the constitutional violation itself. Here, the charges brought against the plaintiff were supported by probable cause. Plaintiff has not pled that defendant's actions had any effect on the existence of probable cause. Accordingly, plaintiff would have incurred the expenses complained of here, regardless of and entirely apart from any actions taken by this defendant. 2, and as argued infra, fuck, I hate infra. I hate supra. You know what supra means? Supra means above. Infra means below in a legal file, or like in a legal filing. Infra, INFRA. below, BELOW, you'll note we got the same number of fingies up on each hand. Supra, SUPRA, above, ABOVE, same fingies. If you're not saving any fingies, just use above or below. The Latin sucks. Every time we use Latin just to make ourselves sound smarter, stop it, lawyers. There is no cause for supra and infra ever, full stop. Yeah. So, 2, and as argued infra, the interest protected by the Sixth Amendment that guilt shall not escape or innocence suffer has been independently preserved. Plaintiff's conviction has been overturned. Yes, but he needs the money to have a fair trial. Accordingly, defendant respectfully requests this court dismiss plaintiff's complaint pursuant to rules because defendant's alleged constitutional violation did not contribute to the attorney's fees incurred by plaintiff in his underlying criminal trial. I'm trying not to be mad at the lawyers for writing this, but I'm still kind of mad at them for writing it. Lindsay, in the award-winning special film series Comes Now, there will not be tops or bottoms, only infras and supras. I hate that because it's good enough that I'm angry I didn't come up with it. It's like, how dare you have an idea that good before I could have that idea? Oh my God. All right. Irrefutably, whether defendant acted improperly and tampered with the jury or not, spoiler, she did. The plaintiff was, in either event, going to face a verdict of guilty or not guilty from the jury. Accordingly, whether guilty or not, the plaintiff would have most certainly incurred the exact same amount of attorney's fees he now seeks to recover from the defendant as damages in the present case. Yes, but that would have meant something, right? It would have been actually like a productive expenditure instead of a waste expenditure. So, because defendant's conduct could not have caused these damages, defendant is entitled to dismissal. So, a damages award compensating plaintiff for the cost of his underlying criminal trial would not be tailored to the interest protected by the Sixth Amendment right to an impartial jury. I want to see this argument because I'm just like, how the fuck do you actually get that? So, the integrity of and public confidence in our criminal justice system is derived directly from the concept of fairness, as justice must satisfy the appearance of justice. The interest in fairness is reflected in the broader dual aim of America's criminal justice system, that guilt shall not escape or innocence suffer. This interest in fairness is achieved and protected in part by both the Sixth Amendment right to an impartial jury and you said by both, and then you list one thing. Like, if you're saying it's protected by both things, there needs to be a second thing. This is just how English works. English. Do they speak English in what? The Sixth Amendment, applied to the states through the Due Process Clause of the 14th Amendment, guarantees the state criminal defendants a speedy public trial by an impartial jury. The most priceless safeguard in preserving the concepts of individual liberty and the dignity and worth of every person is the right to a jury trial, which guarantees to the criminally accused a fair trial by a panel of impartial, indifferent jurors. So, a jury's impartiality is demonstrated by its capability and willingness to demonstrate or determine the factual question of guilt or innocence solely upon the evidence before it. So, okay, impartiality is not a technical conception. We're going to skip over some of this bullshitting. They're padding out their shit by going on about like impartiality. To be clear, however, the Constitution entitles a criminal defendant to a fair trial, not a perfect one. Yeah, but I mean, a court's already ruled on this. You're just trying to fight that verdict now. The harmless error doctrine. This ship has fucking sailed. A court has already ruled it's not harmless error. The ship sailed. The ship caught fire. The ship burned to the keel. The keel sunk. The keel was dragged out and carved into like novelty whatevers, you know, tchotchkes and sold at the roadside. Like, this issue is dead. You don't get to relitigate this shit. Like, at all. So they're talking about the Remmer hearing. Well, that already happened. The contact with the jury or juror was not harmless to the defendant. Accordingly, the Sixth Amendment is not automatically violated where there's been a Sixth Amendment, sir. Okay, like a little bit of proofreading, like just a little bit as a treat. Just to treat ourselves. Okay, so all of this shit is relitigating the issues that are already decided by another court. So no Sixth Amendment interest would be furthered by allowing plaintiff to reap financial benefit in addition to being afforded a new trial. He's not benefited. He's not ahead. He's not like... It's not like this is a windfall here. It's not like he's going to be like, yay, I have another 600,000. Because he immediately has to turn around and give that shit back to his lawyers. A partial jury undermines the integrity of the verdict by poisoning the sanctity of the evidentiary process with outside influence and bias, thus betraying the people's faith in the fairness of the criminal justice system. To ensure the integrity of the verdict, the remedy for an impartial jury is a new trial, not an acquittal. This is because the evil of a partial jury is not that it injures the petitioner, but rather that it taints the legitimacy of the verdict. It's also that it injures the petitioner. Motherfucker, it injures the petitioner of... It does injure the petitioner. Which impacts both parties in the adversarial process equally. Fuck you, no. It does not impact both parties equally. I feel like if you try to write this, there should be like an AI that you get to like go over your work. And the AI should be connected to a stick that just like sits behind your monitor. And when you try to write something like this, the stick should just come out and smack you in the forehead to be like, no, don't. Yeah. See South Carolina versus Murdaugh. Commenting, both the state and Murdaugh's defense skillfully presented their cases to the jury. However, their efforts were in vain because the right to a fair trial by an impartial juror was denied. Yeah. Okay. All right. Pop quiz, though. If you're saying that they equally were affected. The prosecutor went home after the verdict, and Murdaugh went to jail. That's not equally affected. Like, oh, well, they both didn't get a fair trial. It's like, yeah, only one of them actually gives a shit. Right? Like, one of them has skin in the game, and the other one is mildly annoyed. And I mean, I feel like this is kind of how the courts see things sometimes. So maybe this will fly, where it's like the mild annoyance of the state is equivalent to the jail time of the accused. But like, fuck that. Plaintiff acknowledges that he was awarded the proper remedy of a new trial, but in order for the new trial to mean anything, he needs to be able to afford counsel, which means open your fucking wallet. Like, this remedy wholly compensates plaintiff for any alleged constitutional violation of his right to an impartial jury, as the very purpose of granting a new trial is to protect the interest of fairness by ensuring the integrity of the jury's verdict. If I am the judge at this point, I am like writing in the margins in red ink of like, here are the places where I want to yell at counsel when this comes up for oral argument. And yeah. So they note the Sixth Amendment would not be served by letting plaintiff continue to benefit from these doctrines in his 1983 suit and be relieved of defense costs from a prosecution trial and double life sentence, which was vacated solely because of these very doctrines. I mean, it's not like he's going to walk out of there with like $600,000 in cash. That's going to his lawyers. Like, Runkle, if a plea deal is hypothetically reached before round 2, what impact would it have on this case? It would create a better argument for Becky to say, we're going to pay less money. But yeah. Without a new trial, plaintiff's 2 life sentences without parole would still stand. It's like, what is he complaining about? That benefit to plaintiff, while enormous, is merely incidental to the purpose of said remedy, which is to uphold the integrity of and public respect for. Okay, this is so much bullshit. All right. Plaintiff cannot recover damages under 1988. So the court, in its discretion, may allow the prevailing party a reasonable attorney's fees as part of the costs. So this applies to civil suits brought under 1983, does not apply to criminal actions. So, all right, they're saying this statute doesn't help. Fair enough. Has never directly addressed the question of whether 1988 empowers courts with the discretion to award the prevailing party in a 1983 action the attorney's fees incurred in defending the underlying criminal proceeding. While there's no consensus among the circuits on the issue, most circuits have held 1988 applies only to attorney's fees incurred in the civil 1983 action, not those expenses related to the underlying criminal action. This is a better argument, but at the end of all of this, I don't know. I feel like yeah, I'm not super thrilled here. I don't think it was written by Chat GPT. Yeah. All right. Fifth Circuit's deviation from the majority's findings demands inquiry and analysis. I don't find this argument to be as bullshit because the costs, I could see that the costs would be towards the 1983 action as opposed to towards the underlying issue that creates the 1983 action. So I don't think this is entirely bullshit. So, and they note here there's a Fifth Circuit decision where they said that because success in the underlying criminal proceeding was required to satisfy the elements of malicious prosecution, the panel concluded these fees were expended as a necessary prerequisite. That doesn't apply here. Fair enough. Good argument. I don't know that 1988 is the path. I think 1983, though, is still a good argument. So, all right. Plaintiff's claim for compensatory damages must be dismissed for lack of subject matter jurisdiction because he lacks Article 3 standing. And I got to set another goal. What should the goal be? Goal. I am looking around at things. I still don't have a good goal. The things that I think would make good goals are things I can't properly reveal. All right, I'm going to do one that will be kind of hedged. It's a pre-reveal to maybe big news to come. And I can't give the full details, but I will give you some hints as to some really interesting things that might be coming down the pipe very soon. Yeah. Article 3 of the U.S. Constitution grants this court the judicial power to resolve cases and controversies. So, pursuant to Article 3, federal courts have the constitutional authority to decide and pronounce a judgment and carry it into effect between persons and parties who bring a case before it for decision. So, the only power constitutionally assigned to the federal courts, this judicial power exists only to redress or otherwise protect against injury to the complaining party. The doctrine of standing honors the limitations inherent in this assignment by ensuring judges attend to actual harms rather than abstract grievances. So the fundamentals of standing are well known and firmly rooted in American Constitution. Are they just saying that he has no damages? Okay, compensatory damages. Traceability, okay. So they're saying he does have potential damages, but not in the way of that. SF in Texas, no, that is not the thing. I cannot. I don't think Rob is married, or if he is, it would be a very big surprise to me. So, Pearl Snaps, September is when I'm planning to go to Texas. So, I should be there the weekend of the 25th in September. And yeah. All right. So plaintiff cannot establish his claimed injuries are fairly traceable to defendant's conduct. So I guess they're saying that maybe he would have been convicted anyway. So whether plaintiff can demonstrate that the expenditures for legal representation during his murder trial are attributable to the defendant's alleged violation, defendant submits that plaintiff cannot. He states he spent the entire $600,000 on his trial defense. He omits any detail outlining when the withdrawal was made or when he began paying his attorneys. Plaintiff's attorneys, however, have publicly stated that the $600,000 was a flat fee, which was to encompass plaintiff's entire defense. Plaintiff's expenditures for legal representation in his underlying criminal trial, a flat fee of $600,000, would have been incurred regardless of the alleged constitutional violation. Oh, it's a rehash. We already heard this. Defendant played no role in seeking warrants for plaintiffs, but you caused it to be wasted. You caused the money to be wasted. Honk Banana, no, I'm not going to read that one. I'm sorry. I just can't. It becomes a pain in the ass. I'm sorry. Can't do it. Yeah. I appreciate you, but I can't read it. So, and I just knocked down my cell, which is unbroken. Yay. All right, we're just going to set that out of fidget distance. So when a defendant has no role in enforcing the law at issue, it follows that the plaintiff's injury allegedly caused by that law is not traceable to the defendant. Except she directly acted, right? September 25th, that weekend. I don't know when exactly I'd be doing a thing, but I will try to arrange a meetup. I got to get on planning that. So, accordingly, plaintiff's complaint fails to demonstrate traceability for his compensable damages claim, as there's not a sufficient causal nexus between the injury and the conduct complained of. Moreover, to the extent plaintiff attempts to distinguish between incurring legal fees because of defendant's alleged constitutional violation and defendant's alleged constitutional violation causing these funds to be lost, such a theory begs yet another question of causation. Plaintiff's causation theory is grounded in the assumption that defendant's alleged jury tampering influenced certain jurors to vote guilty as opposed to not guilty, resulting in a violation of his constitutional right to an impartial trial or impartial jury. Again, this is relitigating the events. So you're trying to relitigate the facts. Taking plaintiff's allegations is true. 9 jurors heard none of the defendant's impermissible statements and based their opinions solely on the evidence before them, i.e. you would have been convicted in any event. So even if, as plaintiff alleges, defendant's actions somehow improperly influenced the remaining 3 jurors to support of a guilty verdict, such actions would have resulted, per plaintiff's allegations, in a mistrial at most. No, that is speculative as fuck. You cannot determine that it would be a mistrial because just because 9 jurors voted to convict, they might have been swayed to acquit. You can't. Oh my God, you cannot conclude this. And I would just like to cite like 12 Angry Men. Like, come on, you cannot conclude this. So in short, even accepting the plaintiff's allegations is true, the loss of funds used to pay plaintiff's legal fees in his underlying criminal trial was not caused by defendant's alleged constitutional violation. The same might well have occurred absent any constitutional violative conduct on the part of the defendant. Sure. And if I shoot Bob in the face and pop his brains out through a hole the size of a grapefruit and spatter them on the wall, it is entirely possible that he was going to have an aneurysm anyway. It's entirely possible. But he didn't because I shot him in the head. And so therefore, I get held to account. So it is entirely possible that there might have been a mistrial in a fair thing. But there wasn't because there was jury tampering. And so you don't get to go, well, what if I hadn't done the incredibly inappropriate thing? You did the inappropriate thing. Like, you did. So move the fuck on. And like dig out your checkbook. Furthermore, if plaintiff wishes to contend the expenditures for legal representation was not a flat fee, but rather based upon a billable structure itemizing the work done by his attorneys, plaintiff must again rely on a highly speculative theory of recovery. Plaintiff was indicted for the murder of his wife and son, as well as 2 counts of possession of a weapon during the commission of a violent crime. Plaintiff's murder trial lasted a total of 40 days. Contends that the constitutional violation began 29 days after the trial began on February 21st and continued for 11 days until plaintiff's sentencing. Therefore, to prove defendant's alleged constitutional violation caused plaintiff to lose $600,000 in attorney's fees, plaintiff must submit evidence revealing but for defendant's actions, he would not have incurred $600,000 in attorney's fees within this 11-day period. No, this argument is stupid. This argument is fucking stupid. Absolutely idiotic. Let me explain why this thing is super fucking dumb. Let us imagine that I am a boat builder. And I am building a super yacht for some super rich douchebag. And this super yacht is going to cost like $70 million, right? And it's going to take me 40 days to make with me and my team and whatever else, right? And so we spend a whole bunch of money building this super yacht. And we get it, we get 29 days into building this super yacht. We put a whole lot of money in. And then, we're getting to the last 11 days. And some douchebag comes aboard and drills a hole in the floor. And the super yacht sinks and is entirely destroyed. It somehow sinks into a volcanic chasm. Nothing is recoverable, right? my losses are not just the money I would have spent in those further 11 days, because the action taken at day 29 also destroys all of the work taken up until that point. And so this argument is fucking dumb. And this argument is getting to the point, like, this is an argument I wouldn't make. And I wouldn't make it because I wouldn't consider it to be proper to make this argument, because I think this argument is misleading and not proper. Like, this argument is stupid to the point where I think it is a problem. Like, this is fucking dumb. Dumb. And so this is dumb to the point it's making me mad. And the thing, I can't say it's bad faith because the lawyers might just be being stupid right now. Like, the lawyers might be being idiotic. And I can't say. But if it is bad faith, this is an argument that, like, you know, I would find is a problem if you're making it. But I mean, this is fucking dumb. So dumb. Finally, even if this court were to accept this speculative theory of recovery, no, it's a perfectly legitimate theory, and in fact makes a lot more sense than the bullshit you are shitting out of the back end of a bull, which just happens to also be your mouth. At first blush, and by way of simple estimation, it facially appears the plaintiff could only show he incurred $165,000 in attorney's fees based on stupid math. Like, if you accept stupid math, then it gets to numbers that are way lower. Okay, but, like, maybe some of us are... Like, if this is the way you think about things, then I just kind of expect that if you ever go in for, like, neurosurgery, they'll crack open your skull and it'll just be full of baby corn. You're like, oh, baby corn. Tasty. Okay. Assuming plaintiff's complaint is a true reflection of the attorney's fees incurred in the underlying criminal trial, and assuming arguendo that his attorneys were paid only for the days upon which plaintiff was on trial, plaintiff incurred $15,000 in attorney's fees on each of the 40 days that he was on trial. Accordingly, pursuant to the complaint, plaintiff incurred $435,000 in attorney's fees prior to defendant's alleged constitutional violation, which ruined the previous $435,000. You fucks. And not even good fucks, like you lazy ass fucks who are just laying there, not contributing anything to the fuck. It's not even good fucking. It's the plaintiff's asserted injury, loss of attorney's fees in his underlying criminal case was not caused by defendant. Further, any potential causal connection linking the loss of attorney's fees to defendant's alleged constitutional violation is simply too speculative, too attenuated, and too weak to support Article 3 standing. The damages alleged by the plaintiff were not caused by the alleged constitutional violation by the defendant. Also, why are they citing to math? Why do they have footnotes to math? 6,000 divided by 40 equals 15,000. Why is that a fucking footnote? Also, like, Murdaugh is the person who's supposed to be making me lose my shit. Like, how is it that he probably killed multiple people and I'm more angry at these lawyers? Okay. The doctrine of ripeness bars present resolution of any potential claim for compensatory damages resulting from defendant's alleged constitutional violation. They're like, your damages are the future trial costs, and so you can't sue for those yet because they haven't happened yet. All right. I mean, the court might accept this. I wouldn't if I was the court, but yeah. Accordingly, and as argued supra, fucking hate supra, plaintiff has failed to state a compensable claim under 42 USC. The theory of damages alleged by the plaintiff have been largely rejected by the United States Court of Appeal, and even had they not, were not caused by the defendant's actions. However, to the extent, if any, that this court is willing to construe plaintiff's complaint as alleging that his damages stem not from his first trial, but instead from his upcoming retrial, such a claim is not yet ripe. Lawyer pleadings often sound like the narcissist's prayer. You familiar with the narcissist's prayer? I'm going to pull it up here. So the narcissist's prayer is a poem that says, that didn't happen. And if it did, it wasn't that bad. And if it was, that's not a big deal. And if it is, that's not my fault. And if it was, I didn't mean it. And if I did, you deserved it. And the thing is that this is how legal pleadings often go. Because legal pleadings are like, you know, Bob gets run over by a truck. And I'm like, my pleadings, you know, the pleadings in defense might be, Bob wasn't hit by a truck. But if he was, I wasn't driving the truck. And if I was driving the truck, I didn't hit Bob. And if Bob was hit by me driving the truck, he wasn't injured. And if he wasn't if he was injured, then it wasn't that bad. And if it was that bad, then, like, you know, Bob's got unclean hands. You know, something along those lines. So that's what they're doing right now. It is, believe it or not, appropriate to file this kind of thing. So, all right. Plaintiff does not request nominal damages. No, he's requesting $600,000. Cool. All right. A case is fit for adjudication when the action and controversy is final and not dependent on future uncertainties. Conversely, a claim is not ripe when it rests upon contingent future events that may not occur as anticipated. The best argument they have here, like the best argument for Becky Boo at this circumstance, is that Becky can say, look, it was $600,000 the first time. But how do we know it's going to be $600,000 the second time? Right? Maybe the second time he pleads out and his costs are only, you know, $20,000. I can see it, but my counter argument, if I'm Murdaugh or Murdaugh's counsel, is, yeah, okay, you wasted the $600,000. That goes to pay the lawyers, and at the end of the day, the fact that the second trial is, you know, $15,000 should not accrue to your benefit. So, yeah. All right. So they say plaintiff has not yet suffered any damages because of defendant's alleged constitutional violation, as the potential retrial has not taken place, and therefore any potential legals costs to defend such retrial have not been incurred. My argument, if I am Murdaugh's counsel here, is to say the costs are already perfected. because he spent $600,000 on an unfair trial. That perfects the costs. Done. Dusted. Any future trial is not contaminated by Becky. It's the actual fair trial. So, accordingly, defendant respectfully requests for this court to dismiss plaintiff's claim of compensatory damage for lack of subject matter jurisdiction. Okay, so now they're on to 11th Amendment and under the doctrines of judicial immunity and qualified immunity. So she's saying, the law says I am fine. So, as argued supra, smack, plaintiff's complaint is subject to dismissal pursuant to the rules. Okay. And they're saying defendant would nonetheless be entitled to such dismissal based on her immunity under the 11th Amendment, judicial immunity, and under the doctrine of qualified immunity. So these are doctrines that protect government officials from sort of ordinary lawsuits. These immunities are properly raised in a Rule 12 motion, where the Supreme Court has held that such immunities are immunities from suit rather than mere defenses to liability. Such immunities are effectively lost if a case is erroneously permitted to go to trial. Here, defendant is entitled to immunity under the 11th Amendment. Plaintiff alleges the defendant, is a constitutional officer of the state of South Carolina, elected as the clerk of the court by the citizens of Colleton County, and that the actions taken by defendant were taken within her official role. Really? Her official role was jury tampering? All right. Similarly, defendant is entitled to quasi-judicial immunity, where the actions complained of by the plaintiff were judicial in nature and related directly to the defendant's judicial responsibilities. They were not fucking judicial in nature. Oh my God. I want to see the response to this, but this is making me mad. Jury tampering is not part of the job. In fact, the job is specifically do not tamper with the fucking jury or the regular jury, right? No tampering at all should be engaged in. So as plaintiff alleges in his complaint, former Chief Justice Jean Toll denied plaintiff's motion for a new trial, finding that the defendant's conduct amounted to harmless error. That was reversed. That was citing to a decision that was reversed is stupid. The violative nature of defendants the South Carolina Supreme Court reversed the decision, acknowledging throughout its opinion the difficulty, the complexity, and the conflicting jurisprudence of the Sixth Amendment inquiry. The violative nature of defendant's conduct, then, was neither readily apparent nor obvious to former Chief Justice Toll, nor to the South Carolina Supreme Court. It could but have been wholly lost on defendant or any other reasonable clerk of the court. Are you fucking high? No, I do not see that at all. The appellate court found that it was not a difficult thing to determine that her actions were wrongful. What they found was that it was a difficult thing to determine how to approach it on appeal. But, yeah. Defendant is entitled to immunity under the 11th Amendment. So the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state. So the withdrawal of jurisdiction effectively confers an immunity from suit. So basically this prevents Texas from suing California, right? So the Supreme Court has consistently held that an unconsenting state is immune from suits brought in federal courts by her own citizens, as well as by citizens of another state. Absent waiver, neither a state nor agencies acting under its control may be subject to suit in federal court. So they're saying she's a state agent. Further, 11th Amendment immunity extends to arms of the state, including state agencies and state officers acting in their official capacity. So because a suit against a state official in his or her official capacity is not a suit against the official, but rather is a suit against the official's office, and is no different from the suit against the state itself. Therefore, 11th Amendment immunity protects state agencies and state officials sued in their official capacity from liability for monetary damages under the law. The South Carolina Tort Claims Act expressly provides that the state of South Carolina does not waive 11th Amendment immunity and consents to suit only in a court of the state of South Carolina. So I don't know enough about 11th Amendment issues. I'm just going to say that straight up. It doesn't come up a lot in the cases I read. So I am going to have to read more 11th Amendment shit to sort of address this, but maybe this will work. I don't know. I'm going to have to look. So, defendant is entitled to quasi-judicial immunity. So, they say the absolute immunity from suit for alleged deprivation of rights enjoyed by judges is matchless in its protection of judicial power. It shields judges even against allegations of malice or corruption. So what this means is, like, you can't sue a judge for your conviction, right? The judge is protected. You can sue potentially some other people, but not a judge. I really like this idea of having Andrea weigh in. I will reach out. That actually sounds like a fun one. So quasi-judicial officials are officials whose duties are comparable to those of judges or prosecutors, and they're are likewise entitled to absolute immunity. I don't know that Becky Boo fits into that category. She's a clerk of the court, but she doesn't exercise that kind of authority and discretion. So, and such immunity extends to judges' subordinates for functions that are more administrative in character that have been undertaken pursuant to the judge's explicit direction. The judge did not explicitly direct her to tamper with the witnesses, though. That was her own call. Accordingly, clerks of court are generally afforded quasi-judicial immunity from suit on claims involving tasks so integral or intertwined with the judicial process that these persons are considered an arm of the judicial officer who is immune. But she acted on her own. So, yeah. June Sidlauskas, thank you for supporting me when my husband had his cancer surgery. I hope he's doing all right. So, yeah. So, judicial immunity applied to clerk who allegedly failed to deliver judge's writ of habeas corpus to the appropriate parties. Yeah, that's a different thing, though. As with the 11th Amendment, it protects them from liability, but also from the burdens of litigation. So they're alleging that this was within her role as clerk of the court. I don't know that it is. They're saying that her contact with and caretaking of the jury was integral to the judicial process. Yeah, but she stepped outside that into stuff she obviously is not supposed to do. Defendant is entitled to qualified immunity. Qualified immunity sucks. Qualified immunity is something that the police use to get away with shit all the time, and it'll drive you nuts if you look at it. And yeah, it is a thing. All right. So, frustrating. Okay, carrying on here. So in Harlow versus Fitzgerald, the Supreme Court held that government officials are shielded from liability in civil actions if their conduct does not violate clearly established statutory rights of which a reasonable person would have known. A reasonable person would have known not to contaminate the jury. So, standard created in Harlow is an objective standard and is based upon the state of the law at the time of the alleged violation. The purpose of qualified immunity defense is to enable government officials to carry out the jobs free of the fear of civil liability for every mistake they may make and to protect them from the expenses of litigation, the diversion of official energy from pressing public issues, and the deterrence of able citizens from acceptance of public office. But it should absolutely deter a Becky Boo out there who hasn't yet run from public office from running for public office, right? Government officials performing discretionary functions generally are shielded from liability for civil damages insofar as their conduct does not violate clearly established statutory or constitutional rights. I feel like the Sixth Amendment is a clearly established constitutional right, of which a reasonable person would have known. I feel like a reasonable person in her shoes would have and should have known this. And this is also why she denied doing the shit that the court found she did. Because, a reasonable person knows that shit is not proper. Reliance on the objective reasonableness of an official's conduct, as measured by reference to clearly established law, should avoid excessive disruption of government and permit the resolution of many insubstantial claims on summary judgment. Additionally, qualified immunity provides ample protection to all but the plainly incompetent and those who knowingly violate the law. I mean, the finding was that Becky Boo did this for financial gain. When you're talking about knowingly violating the law, like somebody doing it for financial gain is pretty much what they're talking about here. So Malley versus Briggs talks about this. The contours of the right must be sufficiently clear that a reasonable official would understand that what he's doing violates the right. Yes, that applies to Becky. That is not to say an official action is protected by qualified immunity unless the very action questioned has previously been held unlawful, but it is to say that in light of pre-existing law, the unlawfulness must be apparent. I mean, it was fucking apparent to any reasonable observer. So, Fourth Circuit of Court of Appeal explained the rationale. The grant of qualified immunity to government officials ensures that these officials can perform their duties from the specter of endless and debilitating lawsuits. Without such an immunity, the operations of government would be immobilized. Permitting damages suits against government officials can entail substantial social costs, including the risk that fear of personal monetary liability and harassing litigation will unduly inhibit officials in the discharge of their duties. So, granting a defendant's motion for summary judgment is particularly appropriate in cases involving a qualified immunity defense, as the defense exists not merely to protect governmental officials from liability, but to protect them from trial. The Fourth Circuit has strongly espoused a preference for resolving civil rights cases involving qualified immunity short of trial, if possible. The court in Turner also noted that qualified immunity entitles the defendant to dismissal unless there's an issue as to whether the defendant in fact committed a violation of a clearly established law. Therefore, to determine, I feel like it's clearly established that you cannot tell the jury that they to vote one way or the other. Like, this is basic shit. This is the basics. This is the round peg goes into the round hole of being a clerk. Therefore, to determine whether a defendant is entitled to qualified immunity in this case, the court must make three determinations. First, the court must identify the specific right allegedly violated by the defendant. Second, the court must determine whether, at the time of the alleged violation, these rights were clearly established. Finally, the court must determine whether a reasonable person in the defendant's position would have known that his actions were in violation of another person's rights. Yes. All right. So they cite to more case law here, and it's a big block of text that is really just rehashing the stuff we've already gone through. In determining the right allegedly violated, a court evaluating a claim of qualified immunity must first determine whether the plaintiff has alleged the deprivation of an actual constitutional right at all. Yes, they have. The Sixth Amendment. That was already established. That was found. Like, that was a finding. So they're going over a lot of shit here, but yes, that was found. In his final reply brief in his appeal before the South Carolina Supreme Court, plaintiff acknowledged that the facts of this case are admittedly novel. To undersigned counsel's knowledge, this has never happened before. But that doesn't mean... Just because the facts are novel doesn't mean that the result of those facts is unclear. Like, to my knowledge, no one has ever peed on the Pope. But that doesn't mean that the legal implications of walking up to the Pope, whipping out your dong, and just hosing the guy down are unclear. It's just, in fact, that it is so fucking clear, the legal implications of peeing on the Pope, that nobody has ever needed to try this to find out, right? Like, just because it's never happened before doesn't mean we don't know how it works out. So, like, you know, nobody has ever bombed the space shuttle. And, like, but we know what would happen. Like, we know that it's wrong to do that, right? This is not difficult. Come on. Defendant's counsel, come on, do better. All right. Plaintiff then, in order to overcome defendant's plea of qualified immunity, must show that at the times alleged in plaintiff's complaint, it was clearly established that a reasonable person in defendant's position would have known that her conduct rose above the level of harmless error and constituted a Sixth Amendment violation. Yeah, I think everybody would know that trying to sway the jury for money is an issue. So accordingly, the Sixth Amendment is not automatically violated where there's been a constitutional error. Yes, but this they found was an intentional constitutional error for profit. So, yeah. This is because the Sixth Amendment does not aim to eliminate the potential of any constitutional error. The Fourth Circuit has further recognized the limited precedent on both jury bias arising from third-party contact during the course of the trial. In Parker versus Gladden, the Supreme Court found a habeas corpus petitioner was deprived of his rights of confrontation and cross-examination under the Sixth Amendment, made applicable to the states through the Due Process Clause of the 14th Amendment, by way of a bailiff's comments to and in the presence of certain jurors during petitioner's second-degree murder trial. The court bailiff, who was assigned to shepherd the sequestered jury, made two statements to two separate jurors while in the presence of others. "Oh, that wicked fellow, he is guilty." I should make a shirt. I should make a shirt with "Oh, that wicked fellow, he is guilty," because maybe I will. And if there's anything wrong in finding petitioner guilty, the Supreme Court will correct it, which they did. The state, arguing for the case for respondent, contended no prejudice had been shown. By the way, at GameCon, oh, that's what I should set for a new goal. So at GameCon, I will tell you this one for free. I was wandering around with wearing a shirt, and the shirt was one I bought online, and the shirt has a picture of a wizard with a gun, and it says "out of spells, but not out of shells," and I thought it was pretty fun. A couple of other people liked it, so all right. So the Supreme Court dismissed this argument, finding that it overlooked the bailiff's actions as an officer of the court, as well as the state beyond question carries great weight with a jury. The Supreme Court further highlighted the jury's 26-hour deliberation, which in their eyes indicated a difference among them as to the guilt of the petitioner, as well as one of the jurors' testimony that she was prejudiced by the bailiff's statements. Aside from these findings, the Supreme Court held that the unauthorized conduct of the bailiff involves such a probability that prejudice will result that it is deemed inherently lacking in due process. Again, this really seems like it goes to Becky doesn't get immunity. And it would be blinking reality not to recognize the extreme prejudice inherent in such statements that reached at least 3 members of the jury and 1 alternate member. The state further contended that no harm could have resulted because 10 members of the jury testified that they had not heard the bailiff's statements, and Oregon law permits a verdict of guilty by 10 affirmative votes. Supreme Court rejected this argument as well, holding the petitioner was entitled to be tried by 12, not 9 or even 10 impartial or unprejudiced jurors. Ultimately, the Supreme Court reversed the Supreme Court of Oregon, which had held the comment did not deprive petitioner of a fundamentally fair trial. This also establishes that there is that there is prior case law to say that the actions she took, were improper. That this is not new, and this is, well known. All right. South Carolina Court of Appeals has likewise reversed a conviction where a bailiff's response to the forelady that they should not worry if they were deadlocked because the judge was fair was misleading. It tended to lessen the jury's sense of responsibility by implying that if they rendered a verdict of guilty without mercy, the judge had some discretion in sentencing. But again, the mere fact that some conversation occurred between a juror and the court official would not necessarily prejudice a defendant. This is not some conversation. This is again trying to relitigate the issues. Like, you already lost on these. There was already court findings. So there, a juror submitted an affidavit disclosing that during the trial of the case, a bailiff of the court talked about the case in his presence and said that the defendant should be punished. South Carolina Supreme Court found it may be that the court should have punished this bailiff for his conduct and that the juror should have informed the court of the bailiff's conduct. The extrajudicial communication with a member of the jury did not warrant a new trial, as there was no evidence that the verdict was influenced by the bailiff's comments. So they note the Supreme Court further commented that individuals who are selected to serve as jurors must be considered to have personal firmness. I mean, not if they've been in the pool, and conviction, and not to be presumed to bend to every wind of opinion that blows around their ears. Again, this is relitigating the issues that have already been decided, and I don't feel like this is going to succeed here. Certainly, Defendant Hill's comments, as alleged by the plaintiff, were less innocuous than bailiff's comments in Green, which, though inappropriate, related strictly to the administration of the trial. But just as certainly, they fell short of the comments at issue in Parker, Cameron, and Rowell. Okay. This relitigation is not, Similarly, in the case sub judice, why the fuck are they using sub judice as... This just means in the current case. That's it. That's all. So all right. So Juror Z subsequently testified, however, that her verdict was influenced by communication by Clerk Hill and that she felt Clerk Hill thought the defendant was guilty. The prejudiced juror then seemingly recanted this testimony once presented with her prior affidavit, which she testified was a more accurate statement of how she felt. The previous affidavit stated that the juror had questions about Mr. Murdaugh's guilt, but voted guilty because she felt pressured by the other jurors. Similar to Justice Harlan's dissent in Parker, the South Carolina Appellate Court found the evidence of prejudice was trivial and could not be delineated from the internal deliberative pressure from other jurors. Unlike the Parker jury, which deliberated for 26 hours after sitting for 8 days, the jury in Murdaugh took less than 4 hours to reach a guilty verdict after the 6-week trial, which might suggest that Becky Boo was particularly toxic. Further, the bailiff in Parker directly commented on the ultimate issue of the case, "Oh, that wicked fellow is guilty." The Parker bailiff also suggested the Oregon Supreme Court would ensure the petitioner would be found guilty, regardless of any deficiencies. I I don't see how the court gets around here, because this is a motion to dismiss, right? This motion to dismiss is on a standard that is favorable to the plaintiffs. I don't see how they get around the fact that the court already reversed, finding that this was a violation. They're like, it's not so bad. It's a harmless error. And it's like, no, it's already been adjudicated to not be harmless error. So how are you arguing harmless error? So the only similarities, is... Oh, wow, they just argue more harmless error. Accordingly, Defendant Hill is entitled to the ample protection afforded under the doctrine of qualified immunity. For the foregoing reasons, they ask for an order dismissing plaintiff's claims, and that's it. Okay. I think there are some arguments that don't entirely stink in there, but there's a lot of arguments that stink a lot. Okay, I owe you guys a couple of things for the goals. We haven't gotten anywhere on the game con tales, but I do owe you something for the potential spoilers. I cannot tell you why yet. I cannot tell you what big change might be happening. But the spoilers are, I am within a fingernail's grasp of achieving my goal of pro bono lawyering. So I'm within a fingernail's grasp of opening up like Runkle of the Bailey Law. We don't take your money. And it might still fall through. It might. It's possible. But I am so fucking close, I can taste it. And if I do, there's going to be a huge fucking celebration stream. And so I don't want to jinx it. I don't want anything, but I am so close. And fingers crossed. And if it happens, it will be the best thing out of ever. Like, it'll be, you know, a huge thing. So, and if it does fall through this time, that doesn't mean it's done. Just means it's delayed. If we don't get to do it right now, it is, you know, it is, yeah. So here's hoping. The very strong hope is that we are at the, at that. And Michigan Farm Boy, GameCon grifting update, pro bono contribution. All right. If we're at that for the GameCon grifting update, then I need to step away for just a minute so that I can show you some of the GameCon grifting update results. So give me 1 second. I'll be back real soon. I am going to put on some things for you guys to watch, and then I will be back so that I can show you some GameCon grifting updates. Here we go. So I see people debating in the chat as to whether that is Zora or Potter. That is Zora. Potter does not like the Furbo, and so when the Furbo, when you do the treat flicking thing, Potter runs away. So you can actually see Potter briefly in that video, and what you see is Potter running away from it at the beginning. But so I've got some things for the charity auction. Thing number one is a print, and I think this is pretty cool. So I kind of like the morbid / colorful / floral aesthetic. I think that is pretty neat. And that one I just bought. These I got to take out carefully because I don't want them to get too damaged. They're already a little, I got to apologize to whoever buys them. They're a little crinkled. They were in a backpack. So I've got a couple of additional prints that will be going up. So they're both kind of glitch art, and one of them is a TARDIS. And the other one is an Aang. And they're both signed prints, so those will be going up. I also... I just bumped that. I also have a copy of the Fool's Gold campaign setting, which is signed by the developers. So that is also going in, is the signed copy of the Fool's Gold. I set it down and then it fell. There's also a copy of a book by Larry Correa, which is signed. That will be going up as well. Basically, I'm just trying to get more stuff for the charity auctions. I've got some commitments for some stuff that haven't materialized yet. But if you know James Reeves has promised to send some stuff. So that hopefully will be added to the auction. And this year I really want to hit the 500,000 US lifetime goal. If we measure it in Canadian dollars, I'm over 500,000. But I want to, getting another Yaneti tie. I'm going to try. This is the lifetime goal year, right? The year you break 500,000. Yep. That is the goal. James Reeves is a gun YouTuber. He's a great guy. He has offered to contribute. I'm going to reach out to some other people, I know, and just try my best to mooch my best. How much do we need? It's going to be a lot. It is like we have to raise like 118,000 this year. Can we get something Alan Jackson? I'll reach out. I'll try. So, let's cover super chats and then one more story to wind down. Could the Hamani case end up with a firearm restriction being ended for all felonies like tax evasion that aren't dangerous? I mean, there's certainly a good argument for tax evasion and other things like that. It's less of a good argument for things like robbery or, that sort of thing. So certainly could. Brentwood Chic here for the stories. Thank you. Patricia says, lots of luck with getting your car out. I'm going to need it. Honk Banana, no. Runkle, let's talk about how not to crime. Also, Runkle explains in detail how to crime. No, I explained in detail what some people hilariously failed at crime. I'd pay for signed Lawyers and Dragons merch, putting the idea out there. I'll have to talk to Hogue about that, because Hogue is Lawyers and Dragons is Hogue's, right? And I don't want to take Hogue's shit. It is his. So I got to talk to him about that. So most importantly, I kid, how are Zora, Potter, and Leo? Leo, I don't know. Zora and Potter are good, but also kind of shitty. So when it was pouring rain, Potter was super, super anxious. Leo is Rob's dog. So Potter would climb up into the bed and was he wasn't laying down to snuggle. He was standing up in the bed, panting, unwilling to settle down because he didn't like the rain. And it was dude, come on. The other thing is that Potter's fur, Potter never gets cold, right? He doesn't. He'll go outside in he taps out at 40 to 50 below is when he's I'm done. I'm not going to hang out. But at 30 below, he's I'm just going to go chill out in the snow. It's going to be fun. And he'll just go and hang out and just do his thing. So Potter doesn't get cold when he's rainy and soaked and all of that. But he is a giant ass sponge. So he'll go hang out in the rain, come inside. I will towel him off, and he will absolutely this dog just towels and you just towel him for forever. And then he'll be okay, you done? It's yeah, I'm pretty sure you're pretty dry. And then he'll walk in somewhere and he'll shake, and he will shake so much water out. And it's God damn it. Or he won't shake, but he'll go and jump in the bed and leave this big freaking puddle. It's you some bitch. So I gotta convince him to sleep on the carpet when he comes down. So Aqua says, always down for a doggo story. I love the doggos. They're so good. Cosmooks, Runkle, what is the lawyer's opinion on having all my bags say bag of drugs? I don't have drugs. I recommend against that. That is a great way to spend a lot of time with a lot of very annoyed police officers. Aqua says, doggo story, green spot number 10, and off we go. we had a doggo story. We got a few. Honk Banana, no. That reminds me, where's the Bob Knows What He Did merch you promised me? I got to get off my ass. Honk Banana, no. Thank you for the 10 gifted memberships. Laura J. Riker, you're simply amazing. Love how you explain things. Thank you. Josh Glover, so Becky's pulling an episode of Archer, replacing chemo jugs with Zima. Interesting concept. This is fictional Becky, not Becky Hill. Catlin J. Shoot, finally on a live, been busy coaching, Special Olympics, Summer Games medals, medal count, 12 gold, 9 silver, 9 bronze. Thank you all. The athletes love seeing the comments of support. I'm so proud of them. That is amazing. That is really, truly amazing because, they're fucking badasses, quite honestly. So, Mega's autistic, loving the Runkle rage today. Yeah, I'm full of rage. Vez from Quebec, I'm curious, take my money. Fair. Annabelle Feinstein, when were the Dallas dates again? I might be able to make that a trip. September 25, that weekend. D Starfire, just be glad Mr. Poot isn't representing Doodoo Wang, an actual brand. Okay, that is a choice of branding. Banana, no. Becky's lawyers are arguing dumb, fair, but zealous advocacy. So what better argument should they be making instead? There's ways to argue this that are better. It might be the same points, but better argued. So Michigan Farm Boy, is this pound the desk version of a filing? It seems like they're making some pretty desperate assertions. It feels like they're trying to shuffle some things around. And yes, Catlin, absolutely reach out. Laura Leanne, Ian, and chat, you've been keeping my spirits up during our crazy years of hospitals for flu and pneumonia, sepsis, and sepsis shock. Oh, man. Back home and in recovery. Thank you to all of you for your humor and stories. Thank you, Laura Leanne, and if we're making your time a little bit easier, I'm glad for it. Celebral 82, woke up late, here for my favorite part of Monday. Glad to have you here. Dr. Purple Dragonair, leaving my bookmark so I can pick this up on the replay. Enjoy the rest of the stream, everyone. That is a good idea. The Jet JJ, thank you so much. Laura Leanne, goal. Michigan Farm Boy, this is outside the scope of her duty, like the judge that went to a family court participant's house or home to search it was determined to not be protected by judicial immunity because it was outside the scope of the judge's job. I feel like that's a good case for them to cite. Do we suppose there's evidence that Becky had clerk training on not violating the Sixth Amendment? I bet there is evidence on that out there. Darrad says, Advocati Becky Hill Stulty Sunt. I'm not going to try to get to what that means. Gerald Manning, thank you so much. Meme Empress, can you give Florida your reign too? LMAO, I don't have that power. Michigan Farm Boy, GameCon grifting update, pro bono contribution. Thank you so much. And I should roll this because it's fun. Anna Molly 4, here's to the celebration. Come when it may. Thank you so much. Laura Leanne, Runkle, you were hitting all of your goals. Woot, woot. And Lindsay Metcalf, you need an absorber towel for Potter, brand super absorbent. Annual reminder that as you keep intending to set up the auction via website, especially for that sort of thing, so it's not as stressful on stream. We're working on it. We've got, well, I say we're working on it. There are helpful people working on it. I did a video on Ben that went up live today, so it's in a separate video, but we're not covering it in the live. What is it? What is the best way to get a hold of you? Email is the best way. And if you don't get an answer from me by email, nudge me, because sometimes stuff goes into, I got hiccups. Sometimes stuff goes into the spam folder. So if you sent me an email and I haven't responded, nudge me and I will try to look at it and try to find it. So, all right. One last case. We're not quite done. We're going to cover one last case because I've been promising this for like 4 weeks. And you guys have been like, where is it? And I'm like, I can't find it. Well, I found it again. So, yeah. Here we go. Woman charged in Raleigh courthouse shooting had long-running legal battle, records show. So this is from ABC 11. But a woman was accused of shooting 2 attorneys outside the Wake County courthouse, and she'd been in court with them just hours earlier. And this is her. So she appears in the thumbnail. I gave her like double guns because it looked cooler. But yeah. So she became belligerent during the hearing and left the courthouse shortly before the shooting. And what she did was she went to her vehicle, got a gun, and then approached the 2 attorneys in an alley where she shot them and was arrested. But they note that she has filed more than a dozen civil cases since 2022, and she has not been successful with those cases, so far as I know. But let's talk about what kind of stuff she was filing. Because I pulled up one of the filings, and I'm like, why is she having so much trouble? Like, what's going on? Like, is this a situation where she is tragically wronged, or what is this? Like, what is the circumstances of this case? And yeah, So we'll have a look at that. And here we go. So, Gwendolyn E. White. Now comes plaintiff Gwendolyn E. White. I mean, I guess that's better than comes now. A citizen in Wake County, an objection and to respond in writing page by page to Rollsville Police Department Attorney Harris' submission of an RPD memorandum in opposition. And yeah. So she's requesting a new trial on the merits of the contempt order. And she says, and defendants reply that dismissals should stand, even though Attorney Mary Harris stated on page 3 of her motion that ex parte communication occurred with the undersigned prior to the hearing on January 12th, 2026 in a contempt of court order, and the plaintiff was not notified until March 19th regarding this communication. And they're saying this is a, so then they cite to the rules of professional conduct. And then they go with, they tortured and murdered my 90-year-old mother, Ellen Abram White, to death and threw acid in my face twice and on my mother's body. I want justice legally. Plaintiff is requesting the dismissal by Judge Bedford. And they want the evidence reviewed, be formally stricken, fines, penalties, and bank attorney's fees. And yeah. Town of Rollsville and RPD have not acted with the best intentions in response to a citizen's repeated request to stop break-ins, harassment, torture, destruction of property, being followed after moving 5 times. Until now, a murder has occurred of at least one of the residents from that 733 Strathwood Way, Rollsville, NC home. Justice shall be afforded legally. We were poisoned, and I lost 7 liters of blood, and my mother lost 2 liters of blood, as we were both hospitalized for months, and no one tried to stop it. Even after NCDHHS Adult Protective Services got involved and confirmed the harassment was occurred, still RPD refused to stop it. We went through pure hell for 5 years. So, question, why give empty jump drive to the plaintiff other than to stall for time to cut up 3 videos from 3:3:21 verse giving the entire video, or to create drama for the plaintiff to unfold legally, again to stall, especially when Attorney Harris acknowledged clearly in her motion ex parte communication occurred. What is it? If the evidence is deleted in 30 days, why do they have partial video? Double attempted murder with Craig and Michelle Larshield occurred at 733 Strathwood Way, Rollsville, NC, and even Craig confirmed it in open court. That N-word, not N-worded, it's just that N-word. That N-word must die repeatedly, to Judge McCullers. Michelle told Office Alabdaka to shot me in the head and they'll make it appear to look like an accident. And when he refused, she reached for his gun to shot me. Chief David Simmons is very long-time friends of this family, and he's protecting them to the last second. So you can see sort of the kinds of things here, right? This appears to be mental health issues, right? This appears to be mental illness. This appears to be... And so it's easy to kind of laugh at these things and to be like, yeah, this is crazy. Like, look at the stuff. Look at what's been going on. But at the end of the day, she proved to be pretty dangerous, right? If somebody's got these notions in their head, because I'm pretty sure, I'm pretty sure people were not throwing acid at her. I'm pretty sure, all of these things. But, at the end of the day, what ends up happening is she goes and attacks the lawyers. And I'm sure that the lawyers never thought that this was possibly coming. It's kind of, there's people out there, right? And so, yeah, it's, it's concerning. I mean, really, ideally, she should have gotten some help before this happened to prevent this from happening, right? That would have been the ideal. But I mean, these lawyers, I feel really bad for them. I hope they recover. And I mean, I, I don't know what's going to happen to her. I suspect she gets convicted of the shootings and goes to jail for a good long time. What happened to the lawyers? They are wounded. I don't think either of them died. I think that they both went to the hospital and got treated, and I think that they're okay. But so far as I can tell, they seem to be alive. They're still on the law firm's webpage, at least last I checked, and yeah, it's a tragic case at the end of the day. It is kind of like, reading the sort of bizarre allegations is kind of funny, but at the end of the day, like, people do, pretty terrifying things, on some of these things, and it's worrying, right? So yeah, I see somebody saying it was really big news for a few days here. It's it's a big deal. I don't know what's going to happen to this woman. I hope she gets some help, but I suspect that instead of help, she's just going to get jail time for a good long time. So yeah. All right. Let us see what we're doing. Honk Banana No. Tonight's Honk Banana No brought to you by Chestnut Farms Bourbon and Chocolate Bitters. Both are definitely becoming staples. Interesting. And Gerald Manning, 1, 2, 3, 4, 5. Thank you so much. That's much appreciated. What are we get for the goals here? We have speed GameCon tales. Okay. So I owe you guys some GameCon tales. So can I just say I am bad at people. And so GameCon is full of people. And I'm just walking around and it is like maxing out my ability to tolerate things. And so I ended up failing to resist the urge to snark at some of the creators. And when I say creators, I mean like the people who are selling shit. So there's this guy who's selling leather journals. And they look okay. And they're actual leather. But most of the leather journals are just laser cut. And I'm like, okay, so you took a stamp, and I recognize the stamp, and or you took like a die to make the journal, or you're buying journal kits, because a lot of them look like they were journal kits from like Tandy Leather, possibly slightly modified, but and then there was some laser cutting on them. Some of them had some very limited knife work, and so they're like knife cuts made with a round knife, but not any actual stamping or shading or anything like that. So I'm like, okay, like, it's better than nothing, but it's still fucking lazy. And so the edge work on it was a mix of either no edge work at all, like just that the edges were raw edges, or that that the edge work was purely just like edge paint. And the thing is that edge paint, you can get away with doing less work if you're painting the edges, but you still have to smooth, and you still have to cut the edges to make them, not suck. And so like I'm looking at it and I'm like, this work sucks. This is really like lazy shit. and he was selling them for like $175. And I'm just going like, man, there was another guy who was selling things, and I recognized the kit. Like I recognize exactly the die. Like I'm just like, I see the pattern that you're using, and I know exactly where it's for sale. Like literally, it is on Etsy that you just buy this pattern. And I'm like, okay, cool. So you didn't develop the pattern, fine. But all right. And the edging on it was so bad, so bad. And I'm just like, you've got to be kidding me. Like all of this stuff is just so awful. So I was getting snarky because you'd have people who were like, you should buy this. And I'm like, not in a million years. This is dog shit. Which, not great. I went up to, there was a Lego table, and it was a Lego table from like, I forget the group, but they make Legos. Like they're a Lego club. They're not selling anything, but they were just like demonstrating their Lego prowess with, various Lego constructions. And so I went up, and I like, one guy was just sitting there. He clearly didn't want to do anything other than just sit there. He'd rather be home playing Legos. But so I went up to this guy, and he's sitting there, and I'm like, hey, I got a question. The guy's like, yeah. And I'm like, have you heard of bricks and minifigs? And he's like, oh, fuck those guys. I was like, gotcha. And he's like, yeah, no, fuck those guys. And I'm like, cool. That answers my question. Like, that's what I was curious about. And so yeah, his entire take was basically just fuck these guys. And I was like, all right. So yeah, that's kind of I thought that was pretty funny. The guy's just like, yeah, fuck them. I don't have much time for them. And I was like, cool. And what else? I played a D&D game that was actually quite a lot of fun. And did I ask them the plural of Lego? No, I don't really care. I know people get upset with me when I say Legos, but I don't care. I played a D&D game that was a lot of fun. It was just a drop-in game. I actually was thinking of bailing on it and going home, and I'm glad I didn't, because I actually had a lot of fun. What else at GameCon? I ran into a lawyer who was quite pleasant. It was actually quite nice to chat with the lawyer, and I regained some social battery by chatting with a few people there, and that was nice. Otherwise, I mean, it's not the greatest like convention, but it was fun. There were some things that I enjoyed looking up. I'd go back, but yeah, I'll just have to see sort of what all is going on. And yeah, I'm not sure what else to say. If I want to go full odd THD, Lego Train Club stuff is great. Yeah, this is where I want to go. Come to DEF CON next. I want to go to DEF CON so much. I want to go to DEF CON so much. All right. Yeah, I think that's everything. I'm going to wrap it up here. I might try to get some sleep. I hope to have some news for you soon. And yeah, Trash Account says I'll be there to say hi if you do. Tickets already paid for. When is DEF CON? Because I might not be able to go this year, right? I got to see, because I'm hoping to have some upheaval. I got to figure that out. All right. August 5th to 11th. I probably can't go to DEF CON this year then. There's a bunch of shit in that time frame. So I've got like a friend's wedding, and she'll get really pissed if I blow it off, because you can't really blow off a friend's wedding. It's not like a thing you can do. And you certainly can't blow off a friend's wedding and be like, don't worry, I'll go to the next one. That's not a thing. I gotta see. I might be able to make it work. I'll have to see. It's possible. So, all right, let's wrap things up here. I'm gonna say goodnight and thank you all for joining me. See you next time.